And just like that, ladies and gentlemen, we are back. You saw the thumbnail. You saw the title. You know what we're going to be doing. We're going to be getting into the weeds. We're going to get into the legalese weeds. So I'm telling you right now, make sure you got your pen and your paper. You got your smartphone. You got your dumb phone, because we have an expert here who's going to be dropping some knowledge on us today. So thank you to everybody who's already jumped into the best live chat on the internet. I appreciate y'all. Thank you so much. Shout out to you. Good to see you. Good afternoon, my friends. Good afternoon to you as well. Mr. B up in here, sending a wave. Got those green hearts in there as well. Hey, Stacy. Now, I know you all have heard about it. I know this is not something new. Candace Owens is getting sued, right? That's just the reality of the matter, whether it be from the Macrons, whether it be from some other entity, whatever. Candace Owens tends to get sued quite a bit. So what I've done is I've reached out to Nick Brooks, who is a fantastic legal expert who has been on YouTube really crushing it. So I'm glad he took the time to come in today and just to share with us a little bit about where this case is going and all the complexities and all that kind of good jazz like that. I do want to say thank you to everybody who dropped their question in the comment on my community post, because we're going to go over those, and he's really chomping at the bit to go over those with you all as well. So shout out to everybody. I appreciate y'all for sure. We international up in here. That's right. Good to see you in Ireland in the building. Good to see you. I appreciate each and every one of y'all for tapping in. Hopefully you had a beautiful, wonderful Christmas. We got a few more days left in 2025. So we're going to end on a good note, Lord willing. So everybody, with no further ado, let me go ahead and get my guest up in here, Mr. Nick Brooks. How are you, sir?
Good. How are you doing, JWhit?
I'm doing quite well. I'm a little underdressed, man. Nick, you're always dressed spiffy. So next time I have you on, I will have the suit on. I will have my shirt and tie on. I'll be ready. But in the meantime, thank you so much for taking your time today. How are you doing?
Very nice. Hey, everything's ready to go this morning. Had the coffee, so.
Oh, can't be mad. You got the coffee ready to go. Now, Nick, just in case anyone doesn't know who you are, do you mind just giving me your quick 30-second elevator? Who are you? What are you about? All that kind of great stuff.
Yeah, absolutely. Well, I'm Nicholas Brooks. I'm an attorney. I'm located in San Diego, California. I have a Southern accent because I'm from Columbia, Tennessee, about an hour south of Nashville. I attended law school at Rutgers University, a school in New Jersey, pre-existed the founding of America, actually. And I've been practicing attorney now for 2.5 years, licensed, but I've been doing law for many years prior to that. So.
Gotcha. Now, did they give you any hassle about your wonderful Southern accent out there on the West Coast?
Oh, for sure. I get it all the time. Like when I go out, it's one of the first things about me, and but it's very memorable. You stay in people's minds, and maybe they'll think of you, in the future.
No, I got you. I love it. All right. Well, Nick, I don't know if you know, but Candace seems to get a couple of lawsuits every now and then. And so my audience has some questions, and I'll bring those questions on. I just love for you to maybe tackle these and help us out with these. These are some questions I asked my audience. I just said, hey, we got this legal expert. He's a spiffy dresser, and he's going to be addressing Candace versus everybody, because it just seemed like everybody's against her. She puts herself in a position where she's against everybody. So there's some great questions that came up, and I'll just start with this one real quick, Nick. And let me drop us down a little bit. That does not look right. That's a little bit better. I want to know how she can lie like this with this huge platform and be able to get away with it. Why isn't social media censoring her like they did other conservatives during the Biden reign? Remember, the misinformation stance would quickly get your channel suspended. Something is wrong that you can make all these false accusations, speculations, and flat out lies and be paid for it. Is there a reason why you feel, Nick, why is Candace allowed to keep doing this and be out here like that?
Yeah, so really you have to let the judicial process play out, right? So if somebody feels that their legal rights or reputation have been harmed in any way, they'd have to take action in court. But until that occurs, the offender's usually not going to stop the conduct, which is, offending conduct, until they're threatened with it. And with respect to the social media, censorship, ultimately when it comes to any platform such as YouTube, X, or Facebook, you name it, A lot of these are private companies, and private companies don't have to govern the same way as the government or a public entity does. So a private company can discriminate, based on the basis of political opinion if they would like. The government, typically has more issues in doing that. So that's kind of how I would frame that issues, with the censorship. I would maybe even pose to the commenter, would you like to see censorship of some sort? Because the way I read the question was like maybe they didn't appreciate the censorship, in the past. So that would be my other question. But when it comes to just regulating the information spread by Candace Owens, I think you just have to take the proper causes of action available in civil courts.
Okay, I can dig it. I'm going to take a little bit of a jaunt because there's a question here that really stood out to me. I don't know if you're familiar with this whole Candace found this quote unquote witness. And this guy really is the glue that holds together a lot of her Rube Goldberg theories. A lot of her theories are hinged on this guy named Mitch Snow. And he came on her channel recently and shared his story and, pulling on the heartstrings, small violin. And Candace started a give, send, go for him. And at the current moment, I think it's like $142,000 has come in to this give, send, go. Well, since then, it's become pretty clear this guy was probably lying. It's just an outright fraud. Okay. So this question right here, I want to get in here and ask, what are the repercussions of Candace hosting or somebody hosting a give, send, go for somebody that later on is found to be fraudulent or found to be...
Just to be clear, a give, send, go, he received money like through donations of that nature?
Correct. It's kind of like, it's like that, whatever that crowdsource funding app. It's called Give, Send, Go. But what's the other one called? I can't remember off the top of my head.
GoFundMe or something like that?
There we yes.
Yeah,
it's like a GoFundMe. Yeah.
Okay. All right. Yeah. Well, when it comes to that, I've heard of in the past cases involving potential fraud on these GoFundMe. It sounds like for this guy, maybe he was being propped up for spreading, maybe his own misinformation or lies. I don't really have a lot of facts related to what he said or the nature of his comments. But if they were wrongful, but there's potential liability. You could recover that money depending on the reason it was given to him. But I would have to look more into the factual specifics of the case to know that.
I got you here real quick. I'll bring it on just real quick so you can see what I'm referring to. Sorry about that. That is way too small. Let's do it like this. All right. So this is the Give, Send, Go, which is again very similar to GoFundMe. And at the current moment, the guy has raised $143,250. But the problem is a lot of his story and a lot of his background and his military background has been called into question. And military experts have found him wanting, let's just say it like that. They found that this guy's lying about a lot of what he said. So that was the nature of that question for sure.
And what did he say on the show? Was he like talking about the conspiracy stuff?
Yeah, he was talking about how he was on his military base and he saw the head of security for TPUSA. Oh, I'm sorry. And this is 2 days before Charlie Kirk's demise. So he saw the head of security, lots of generals in this secret meeting, and he saw Charlie Kirk's wife allegedly in here. And so he's insinuating that they were all in on the plot to delete Charlie Kirk. And come find out the story is just as wackadoodle as it sounds, me retelling it. And so a lot of people are like, well, the fraud, Candace propped him up as a eyewitness. Come to find out he's found wanton. What about this give, send, go?
Were the give, send, go given to him for purposes of paying his legal fees?
He has some other legal fees going on. So it says helping Mitch pay for some of his legal costs for wrongs done in the past. The way the United States treats our servicemen is positively despicable. The corruption that exists at the top of our armed services needs to be corrected. And that's it. So it doesn't really flesh out what those legal fees are, but he had some legal fees allegedly coming. So that's why the question was asked, like, is he going to be, like, would Candace be held responsible that this guy really truly is a fraud or really?
Yeah, it would most likely be the individuals that are harmed would have to sue him directly. I'm not so sure, you could tie it back to Candace. Did Candace profit from this in any way? or how did Candace wrong them? Because it sounds like whatever money these individuals who gave it, if they didn't want to give it, went to him, not to Candace. So you would have to go after him, I believe.
Yeah, you're probably right. I just was wondering, I think that was a great question that they asked. All right, let's get back over here to our other questions. Thank you so much, Nick. And by the way, shout out to everyone who's jumped into the best live chat on the internet. I promise to get the sizing of this thing right. I do, I promise. All right. Bang. All right, here we go. If Candace gets sued for defamation, can she just claim that her show is just entertainment as a defense and win? So I think it's almost two questions. So can she use it as defense, and do you think it's a winnable defense?
Yeah. So, well, first things first, she has been sued for defamation and with respect to the Owens v. Macron case. So that's actually a pending cause of action. And then maybe even Kirk or TPUSA could have their own. We'd have to see how they do that. And generally, when defamation's pleaded, there's a certain number of available defenses. Truth is a defense. Privilege is a defense. Opinion is a defense. I have not heard of entertainment being a defense. So the way I would answer that is no, entertainment is not a proper defense to defamation. And so that could be subject to a motion to strike if Candace Owens tried to plead it because it's not properly drawn in conformity with the law. And then with respect to winning, yeah, that's exactly, I think I answered the question. If it's subject to a motion to strike and entertainment actually cannot be brought as a defense because it's not legally available, then inevitably that legal theory would fail and it would not be winnable.
I love it. Okay. So let me ask you this. So entertainment has never been used, or you don't see it as being used in this case particular?
No,
Like
I've never
Really?
heard of
Okay.
entertainment being a defense. And for most attorneys, we all study defamation for purposes of the bar, and there's certain
Right.
defenses like truth, privilege, opinion, you name it. And entertainment's just not one, because inevitably, ultimately you could write or say anything and it's just completely false and reputationally harmful, and then say, well, I was just trying to be entertaining. Well, that's the reason we have defamation, is to prevent that type of entertainment in some way.
I got you. All right. No, I appreciate it. Because I guess I was always thinking like, well, has somebody ever tried it before? But then again, we see comedians do things, shock jocks say things, and of course they just claim. But I guess I've never actually heard somebody say I'm just an entertainer. I've heard people say I'm just a comedian, but I guess I've never heard in the legal sense. Okay.
Yeah, and well, the thing is comedians have another available defense at times, and a lot of it can be either considered satire, not serious statements of fact, innuendo. And so there are these available defenses that comedians can use that's not considered entertainment technically as a defense. It's more so falls under one of those other defenses available to them.
Okay. No, I love it. So does Nick ever watch Candace's podcast and think, wow? Well, first of all, have you ever watched any of her content?
No, besides like the highlights I get from different people and stuff like that, I don't really find myself watching all of her podcasts to see what she comes up with, because there's just so much being said and implied that it's kind of overwhelming to an extent. And it's like, What am I trying to read from the situation other than maybe just plotting the world against me or whoever else hidden groups doing it? And so, yeah, with that, I don't really watch it. I try to find more productive things with my time, but I do like legally analyzing it.
Okay. So, and to continue this, have you ever watched a clip of hers? Have you ever watched a snippet of hers and say, wow, this could be an easy lawsuit win against her? And if so, what episode or topic was it? Erika Kirk, Macron's TPUSA. Have you ever seen something that she's done and be like, whoa?
Yeah,
I saw get in trouble for that.
I saw the comment she made about I would, stake my professional credibility on the fact that Brigitte Macron's a man. And so if you're staking your professional, credibility, I mean, we could dive into the defamation part and that lawsuit later, but yeah, I've seen those types of comments, and obviously they ring true with a lot of other clips I've seen, related to that.
I got you. I love it. Real quick, I'm gonna jump back over here. Opinion is a defense. Am I correct?
Yes.
Okay, so I have an opinion that Nick dresses way better than I do on Saturday. That's my opinion. Is that fair? Now,
That would be an opinion. Yeah.
okay, and I could say Nick is a terrible person because he dressed better than me, and so forth. That would still be. And if Nick decided to say, "Well, Jason, you defame me, I'm going to sue you," I said, "Well, wait. That was my opinion about, your suit. It was my opinion about it. That would be a defense. Is that fair?"
Yes.
Okay.
Yes.
Albeit a very bad defense, but I got
yeah, and just to kind of to talk about why opinion is a defense. So generally, if a plaintiff pleads defamation, they have to prove all the legal elements of defamation, and so that is one, a defamatory statement of another published to a third party that caused reputational harm, and there's no applicable defenses. So the first exact element is a defamatory statement of fact, not opinion. And so where we're able to show, hey, this statement in particular is just an opinion, not a fact. And facts generally reveal who, what, when, where, how, why, things of that nature, concrete statements. Opinions just going to negate an element and inevitably serve as a defense.
I got you. Okay. Here, real quick. And we haven't talked about it, but what is slander in reference to defamation? Maybe you can talk about slander, libel, and defamation. Are they all the same things?
Great question.
Help us out with that.
Great question. I actually didn't know this either until I was studying for the bar. So defamation is the umbrella term for causing reputational harm to another through false statements of fact. And so slander is actually oral, defamation. Libel is written defamation. Now, where we're having videos and things of that nature, I'd have to consider. I'd have to consider if that's considered more slander or libel, because videos can be used as technically documents for purposes of evidence law. And so, I'm like, well, is a video considered more libel or is it slander? But a video you're communicating orally. But yeah, that's the general way to look at it. Is slander is oral defamation, libel is written defamation.
Okay, now I'm gonna take a little sidetrack here. Do you foresee the law changing because there's so much libel or slander being presented in the video format? Maybe they might just make it all defamation instead, or maybe say like video is defamation, but if I wrote it, that would be one thing. If I spoke it on an audio podcast, that would be different. But since I did it on video, it's this new category. Do you think that might happen?
Yeah. So with respect to like first definitions and then maybe consequences, I would say for definitional purposes, whether you're considering a video as oral or libel slander really doesn't affect the overall thrust, which is that there's slander or there's defamation going on. And so ultimately you want to attack that, I suppose. And your evidence codes, whatever state you're in, California, Georgia, Delaware, you name it, they likely could have different interpretations of what a video is. Is a video considered quote technically a document, if you will, for evidence code, or could we see a video as oral slander? I would imagine this is kind of getting a little bit of an advanced point, but for purposes I would kind of want it treated as libel immediately, because it's easier to kind of present a document, if you will, so a video. And so that would just be easier to maybe establish for the evidentiary record than oral defamation through slander. And then, with respect to the consequences, as long as you're kind of getting to the thrust of stopping defamatory speech, I'm not so sure it's super consequential whether it is considered slander or libel, because they're both really defamation.
The same thing. I got you. Okay, so this actually brings us into another question. Do you think that TPUSA, Erika, and the people that she's accused, TP, okay, and the people she accused at TPUSA have legal standing to sue her for slander?
Yeah, no, it's potentially. I think we'd have to dive into the facts of the case, and obviously, as I've discussed kind of recently on my episode. So again, we're dealing with defamation. Now, when you're defaming somebody, if that person is just a private individual with no publicity, they're treated different for purposes of defamation law. A public figure, if they're a plaintiff in a defamation suit, has to prove actual malice, which is knowledge of the falsity or reckless disregard for the truth. And, so your statement's false. And so Erika Kirk and TPUSA are public figures. And so for them to state a valid claim, they're going to have to show actual malice, that Candace Owens made these statements with knowledge of their falsity or with reckless disregard for the truth. This is likely why Erika Kirk had this private meeting with Candace Owens, was for purposes of establishing on the record, hey, I'm giving you information and evidence, and that establishes that if you ignore this, you have reckless disregard for the truth, because I'm trying to tell you the truth and you're recklessly disregarding the truth. Same thing with the Macrons. The Macrons sent them, termination letters to stop, cease and desist, stop calling us a man, stop saying we commit these crimes of, they're serious crimes. And so a lot of that is what public figures have to do to establish that the defendant is willfully disregarding the truth and recklessly doing so, and they can be held liable for defamation. So that's a very long-winded answer, but it's very complex for sure.
Okay. All right. Well, let's do this. Since we're going long-winded, go ahead and put your Constitution hat on.
Okay.
And real quick, First Amendment. Are we slipping into some murky waters with freedom of speech? Like, I have the freedom to say something about Nick, but at what point do I get into the point where now Nick can sue me because what I said freely slandered him, or what I said freely hurt his feelings, or my opinion contradicted what he wants? At what point do we get, because it seems like we're on a thin line.
Yeah, it's very difficult. In First Amendment law, you can take an entire class on this in law school, quite frankly. Okay. Generally, as you pointed out, the First Amendment protects the freedom of speech. Our society kind of is founded upon speaking your political opinion and having that freedom of speech to question governmental authorities or private authorities, and you name it. Where does it cross the line is always an interesting question, because at the end of the day, free speech is not absolute. The First Amendment is not absolute. When it comes to, I can't shout fire in a crowded theater. I would be causing an emergency. I could be arrested for that. Could I then plead as a defense? Well, you violated my First Amendment. I should have the right to shout fire in a movie theater. That's not very reasonable. And we have to have some caveats to have a functioning society, or else we might not have functioning movie theaters because people could be alarmed on these events. And so we have to take that type of logic where the First Amendment is not absolute, in the same way we extend it to emergency situations. Well, there's also things like commercial speech. What if there's an advertiser for a product who says false things about the product that aren't actually true? Should we protect against that? And if we prosecute it or file a lawsuit against it, can he just say, well, this is freedom of speech? No, you're lying about a commercial product, and you should be telling the truth about your commercial product. So again, that's just an example of commercial speech also has to be truthful. And when it comes to reputational protection, a lot of us in society, if we're not, very property people and we don't have a ton of wealth or assets, we depend on our reputation for our livelihood and having a good name. And so we want to protect these types of reputations for people. And so what if somebody just starts, says, hey, this person came up on the news, or I want to, slander or libel this, treat libelly this person in any way. How do we protect against that? And so it's a when it comes to defamation law, trying to draw where does the First Amendment go, that's probably a more difficult situation than the emergency or commercial speech ones I mentioned. But ultimately, I think we would all maybe agree we would want to protect reputational harm. So that's, I don't know if I answered your question directly on that point.
No, you absolutely did. And it kind of led into the last question. Is there a path for Erika, TPUSA, or any other people that she's randomly accused, such as Josh Hammer, to successfully sue her? And I think, because you mentioned reputational harm, I think there's definitely room to say everybody that's been listed so far has been reputationally harmed. I feel like I've been reputationally harmed, right? Everybody's been reputationally harmed by some of the shenanigans that she's posted out here, whether they're true or false, whether she really believed them or she's just being hyperbole. I think it's fair to say that to some degree, shape, or form. And I'm concerned that she is so slippery that with the defamation laws in the U.S., she may be able to get away with her slander. What do you think about? Let's just use what she said about TPUSA. Of course, insinuating that they were in on the deletion of Charlie Kirk. They are covering it up. That they're a godforsaken company. That people should stop donating to them. Lots of things that ruin the reputation of a business, of an entity like TPUSA. How do you feel about that?
Yeah. So when it comes to like defamation law, I think some states actually do treat it differently on whether a business can recover for defamation versus an individual human being. And so first things first, whatever state TPUSA decides that they want to file a lawsuit in, they've got to ensure that businesses can recover under defamation law. And that right's not just available to individual human beings. When we look back on the Dominion voting systems, in the election where Tucker Carlson discussed how there was a conspiracy of foreign governments about this Dominion voting system, Dominion actually brought a lawsuit and it ultimately settled. So it never reached a judgment or anything of that nature. But that's an example of a business bringing a suit. And when it comes to trying to predict is a lawsuit going to be successful, I mean, nothing's even been filed. We haven't gathered any evidence. So, lawyers, we're not permitted to provide guarantees generally under our ethical rules. And so trying to guarantee the success of a case is not, something that really good lawyers do because it's kind of professionally, wrongful or not professionally ethical to do. So I can't really predict the success. However, as I mentioned earlier, if they feel they meet all the elements of a defamation claim, speak to a lawyer. And if you're willing to maybe pay an attorney's fee or retainer fee or take the case on contingency, well, you might have a case.
Well, I'm going to tell you right now, on behalf of everybody, Nick, I blame Law and Order and every cop show, every law show, because they get done with this so fast, man. It's so fast. When I found out just how long lawsuits take and court cases take, I can't even watch Law and Order anymore. As much as I love it, I can't watch it anymore because I'm like, there's no way that you resolve this matter in 46 minutes. It's just not going to happen. Like, no, stop it. No.
Absolutely. I've actually said the same thing. Just kind of picking up on that topic, something I've thought about in my own time. I'm an attorney and there's a lot of technological advances that have been made in the last couple of years, especially with regard to AI. And so for judges that actually refuse to get with the times and learn how to use AI better in order to expedite their docket cases, I find those judges to be somewhat rather disappointing and violating typically their own judicial codes on how to act as judges. And so, I think judges have an obligation in the interest of justice and fairness to people to get these cases moving, try to bring justice as quickly as possible, because I think that frustrates a lot of people in our society is just the sheer length of time to bring a lawsuit. And then when you have a lawsuit, the stress that's involved. So I think lawyers and judges have to do a better job at making sure these cases get processed quicker. And I do think with technology advancements, that's a reasonable possibility to occur.
No, I got you. I was going to make a joke. I remember when my wife and I used to watch Law and Order all the time. We used to do the marathons all the time. And I remember in the early years of Law and Order, they used to actually have, when they would go, cut scenes, they would say they would give you the dates. I noticed that they used to give you the date, like January 5th, 2023. And notice now in the newer Law and Order, she still watches it in the new Law and Order. And as for you, they don't give you the dates because I think because they were really messing those numbers up and really causing people duress. Like, wait, this is going to take 2 years? Oh man, 2 years to get the law. Again, we were talking before we came on the YSL trial here in Atlanta. It took them a year to select a jury. So I mean, that was crazy. That was insane. So and it was a total of like 2.5 years. That's crazy. That's the longest case ever in Georgia history. And then they actually got nothing out of it, nothing at all. Okay, let's talk about it, Nick. Talking about Discovery, and we're not talking about the Starship Discovery. What is the realistic Discovery for Candace and the Macrons? And I'm going to start this again. What discovery tools would realistically be available to Candace and to the Macrons if this case survives the motion to dismiss?
Yeah, great question. So, discovery tools are generally governed by state law. So each, litigant has to look to their own state law. As we know, this case is being litigated in Delaware State Court, and so we have to look to the Delaware State discovery rules. Now, generally, when we're speaking of discovery rules, a lot of these are. It's kind of like you're a mechanic and you open up the car hood, and some of it might be a little different, but a lot of it's functioning the same. So we can kind of look at it that way. There's going to be interrogatories. So you get to ask written questions to the other side and have those responses written down under oath. And it just typically narrows the case in certain ways that the litigants would like. There's going to be requests for admissions, which are, written requests to the other side to admit or deny facts. And those are also the responses under oath. We have requests for production of documents, which are, written requests for the production of particular documents, just as it sounds, and the responses are under oath. We have depositions. So, you literally orally examine certain individuals or parties in the case to learn, information or documents or evidence they have to try to build a case. There's subpoenas. Subpoenas are typically to non-party individuals. So, you could, if there's like certain companies or maybe her husband, George Farmer, he could come in through like a subpoena. You could, depose him through a subpoena of some sort. And so there's a lot of discovery tools on the table. Oh, and I did want to mention the physical examination, with respect to, could Candace Owens seek to move for a physical examination of Bridget Macron in any way? And what would that look like and the likelihood of that? So a lot of the videos I've been posting recently and will continue to go up on my page, discuss some of these different discovery tools. And then also, too, we kind of dive into, and I'll be doing this in later videos, Erika Kirk, if she were to bring a case and if that decided a motion or survived a motion to dismiss and move to discovery, potential discovery tools available to her and what that would look like.
So let me make sure, and correct me if I'm wrong. It seems like discovery tools kind of go from a very non-evasive to more evasive as we trek along. So maybe like an email and a memo. Then we get to like call logs and bank records. And then we're getting down to like the more invasive, like, again, bodily fluids and checking, stuff like that. Am I right that discovery kind of goes from the most non-evasive to the most evasive, or is that fair?
The only point, the only point I would push back on is this. If the parties are being evasive, you can motion to compel good faith responses and avoid those evasive responses. You have to obviously generally you have to meet and confer with the other side, go over with them why they are being evasive and what they can do to stop being evasive. And if they don't, correct their conduct and provide less evasive responses or more substantive responses, you can go to the judge and have that ordered that they provide non-evasive responses. And so, if we're dealing with interrogatories, requests for admission, requests for production, depositions, because sometimes, a deponent may be, I'm not going to answer that so clearly. And it could become an issue where you have to bring a motion to compel and get them to answer that. And if you win a motion to compel, you generally recover attorney's fees for the preparation of the motion.
Okay. All right, Nick, we got a couple of questions from the audience. I do have my questions that we're supposed to be going through, but I got the audience questions, and there's some good ones in there. Now, this one right here, Nick, this one's a little bit lighthearted, so just take it as it is. Nick, are you married?
No, I'm not married. I got to get married, though, so I appreciate the question. If she knows a nice lady, let me know.
Okay, well, there we go, man. We got the JWhit love connection over here. We're working on it out. Send me your resume. We'll hook them up. Okay, I love it. All right, Nick, why do you see people say bring on a lawsuit and to sue? And the use of discovery as a way of intimidating people?
Yeah, I think that's a great question, actually. So I think whenever there's a lawsuit filed, obviously lawsuits generally bring stress to people that aren't, accustomed to dealing with them. And so I think that's the first thing is like when people hear lawsuit, they immediately think a stressful situation where, your future livelihood could be up in the air in some way and it's not certain. And we all crave certainty to some extent. And then
sure.
with respect to discovery, I would just say, discovery can be for a lot of people somewhat invasive because, take, for example, this Candace Owens discovery. We may, get to look at certain on the request for production of documents, seek communication. So we could have her screenshot her emails, screenshot text messages related to Bridget Macron, and she is forced to produce those. If she doesn't, she could be sanctioned and things could go against her in her own case. And so I think with that, I think a lot of people don't want their personal and private information out there. But if it's substantially related to the case, you're generally going to have to produce that type of information, especially communications in a case like this. So I think that's what scares people, is the stress and the potential in what they perceive as invasive into their own lives.
Could you speak then with that same what you just said there? Could you speak on fishing expeditions? Like, because I've heard people say the reason why TPUSA will not sue Candace is because of discovery. They're going to get stuff that she's going to be able to use in another, 45 pieces of content, or they're going to just fish. Like, let me see what were you talking to Jason about in the text message? And, I see you said this, and go in a whole nother direction. So can you speak about fishing expeditions?
Yes. And so when it comes to fishing expeditions, obviously that's going to typically occur in the discovery stage when the parties are gathering evidence. And the whole fishing part is like, they don't know exactly what they're going to catch. They're just casting this wide net or throwing out a lot to see what they can pull back or reel back. And, if it's invasive, so be it. And so a lot of people, when fishing expeditions are just very overwhelming to a lot of litigants. And then with the legality of that, you just have to push back on each question. So if they try to seek, like, let's say tax records, right? It's a business. So, the tax information is not as protected as it would be for an individual human being. And so, when it comes to TPUSA suing and they're going to argue reputational damage, and then, with the reputational damage, they might have to show certain aspects of financial loss. We're dealing with, the scope of discovery is going to be able to get all of that all those documents. And so I do believe TPUSA should have a concern related to the disclosure of their internal documents and information processing. And that's not always fishing, because at the end of the day, the scope of discovery is much wider than just the definition of relevance. You don't have to ask a discovery question or request that's exactly relevant, if you will. You just have to ask it within the legal scope of discovery, which is generally, trying to gather facts or information related to claims or defenses. And so long as you can argue whatever you're asking is sufficiently related to the gathering of information or evidence related to this claim or this defense, you're going to have to provide that. And so generally, just because the scope of discovery is broad, it generally permits a lot of fishing expeditions, if you will. And then the lawyers just have to do a good job either objecting to that, requesting motions for protective orders, or if the trial comes up later, ensuring that whatever evidence, was turned over that, they don't want admitted at trial, they have to identify it and then move to suppress it.
So just to ask, okay, I'm suing Nick. Nick is suing me. We're suing each other. And I want your tax records. You want my tax records or bank statements or whatever like that. And I don't want you to see that I have a problem at the Adidas store, man. I go to the Adidas store entirely too much. I spend a lot of money at Adidas. And I don't want you to know that, because you're going to put it out there that I'm an Adidas addict, which, by the way, I am. But I don't want you to I don't want you to have evidence to the fact that I'm an Adidas addict. But that's not even related to our lawsuit. Like, the lawsuit is about whether or not I have a blue Stanley Cup on my desk. So can I get that redacted from there, that the fact that I go to the Adidas store entirely too much? Or do I truly have to give you all of my bank statement? And how does that work as it relates to? I hope that makes sense.
So the way I would kind of approach that question is, imagine you and I had a case involving a battery and assault. Either you hit me or I hit you or something like that, right? It's pretty much an intentional tort involving you and me in that sense, and there's no financial allegations to it. It's just you or me caused each other physical pain. And so if we were doing discovery on this, proper discovery would relate to that battery, such as what emotion did you feel right before you made contact with,
My
Nick
face,
or
yeah.
JWhit? Exactly.
Right.
Did you have any things that happened within the last hour that had caused you, to be emotionally negative or something of
I
that
spent too
nature?
much money at Adidas, man.
Yeah.
I spent a lot of money at Adidas. Now I'm stressed, man. I see you and then I beat you up.
Yeah, exactly. Yeah. No, but and so if you ask for financial information because of a cause of action
Battery,
related to
right.
battery and assault, that's not really gathering information or evidence related to the claim or the defense, which is going to be, battery and assault, and then maybe my or your defense would be self-defense because we likely fought back or something. And financial documents aren't really relevant, nor are they within the scope of discovery for purposes of proving those claims. Now, if you were successful in getting a judgment against me for battery and assault, or I was successful against you, now we need to figure out each other's assets and what do we own, and if it's $1 million or something like that, the judgment, it's a hard punch.
Man. I'm hurt, man. I'm hurt.
The pain and suffering is getting to you. I can feel it. That would be more where financial information would come in, but that would be much more in the collection stages rather than the pre-judgment stage.
I got you. Okay, because you're helping me out. Because nobody's suing me and I'm not being sued. I have a lot of questions about this. So, okay, let's just say it's 2:00 at night. We're down in the bar district. I'm coming out of a bar, and I clock you and hit you. And for some reason or other, I'm able to make it home without getting arrested. But you CCT cameras and such like that. You're like, Jason beat me up, whatever. Would you be able to secure my financial documents or bank records and say, well, we know he walked out of this bar and we want to know that maybe he was drunk when he left out of the bar or anything of that nature? I don't know. I'm very interested in how the discovery aspect, because the way it's been presented to the great unwashed by Candace is that I can discover anything. I can find out your shirt size, how many ties you have, who did that artwork behind you. I can discover everything. But I don't know if that's necessarily true.
Yeah. So when it comes to, I guess like the first question on the walking out of the bar and then punching me, and then here was my initial question: are you disputing that you were actually at the bar and you left the bar? So if you're disputing that, I may have to say, look, he's clearly not giving me the evidence I want. So you know what? Let's go ask for these bank records, and that'll be sufficient to prove my claim or information.
Gotcha.
Now, if you suddenly admitted that you were there at the bar, well, that issue's been resolved. There's no reason to be gathering financial information, And so a lot of discovery does, you want to go more so to issues that are in dispute, I suppose.
Okay. All right. That helps out a lot. And by the way, I don't drink, so don't run and tell my diaconate anything, guys. Don't do it. All right. Here we go. All right, let's go, because this is some good questions. All right. Are the statements at issue actually actionable in defamation when viewed in the full context? Oh, I'm sorry. Oh, I feel like I missed one. I did miss it. Sorry about that. Strike that.
Oh, good.
Strike that. Because
I thought that was a good list too. What you had?
Yeah, that was a good list. But look, I had another question. Here we go. What is Candace's reason for attempt to dismiss the case? A lot of people were here when she was saying, hey, bring it on, sue me, come on and sue me. They sued her, and then the next thing you know, she's filing for a dismissal. What was the purpose of that?
Yeah, so I actually looked up the motion to dismiss and the grounds for that motion to dismiss. And her reasons for wanting to dismiss are, she argues that the court in Delaware, Candace Owens as an individual human being is arguing, the court in Delaware lacks personal jurisdiction over her, and that hearing the case would not be proper in Delaware, and that it's better heard in Tennessee. That's her position. So she disputes that personal jurisdiction is proper. She disputes the venue. And then she also argues for forum non-conveniens, which is an old Latin term that basically means this forum is not convenient and there's another available convenient forum. And she points to Tennessee. Now, when it comes to that, I can kind of pick up on that and those different concepts if you would like.
Oh, yeah, please.
Okay, yeah. So when it comes to just diving through some of these, like, this is very much advanced civil procedural knowledge. I'm talking, there's going to be lawyers going to the bar exam that, quite frankly, do not know how to talk about personal jurisdiction and venue and forum nonconvenience like I'm about to. But when we're dealing with personal jurisdiction, you essentially have to show that, is this, does the court have proper jurisdiction over this person? And to do that, you generally have to show that, hey, the court has general jurisdiction over this individual, such as they live here in this, they're a domiciliary domicile, or is it here in Delaware? That's not going to be here. We don't have general jurisdiction over Candace Owens, the human being, in Delaware. We do for her businesses because, they've registered themselves there.
In Delaware, right.
Yeah, but when it comes to specific jurisdiction, we have to show that, that she's essentially made like sufficient contacts with the state in order to be properly, in order for the case to be properly litigated there. So does she, when we're dealing with minimum contacts with the state, clearly she's registered her business in Delaware. So, with respect to her contacts, I would just say, her contacts go through the business in Delaware, and she clearly has already been here to register it. She's likely on the business registration information for the company. And so I would just argue that she's has enough sufficient specific and minimum contacts to actually be constitutionally fair to have a case against her as a human being in Delaware.
Okay, let me add this also. And I think we talked about this before. She's actually sued. Her business entity has sued from Delaware before. Would that ever come into, when she sued USA Today, would that come into play as well? Like, well, wait, you say you don't have any business in Delaware, but you've sued people from Delaware. Would that come into it as well?
Yeah. And so really, when we're talking about you and who sued, I believe she's suing through her businesses. So the businesses are the ones having the causes of action, not her as an individual human being. She's attempting to make the argument that as a human being, I lack sufficient contacts with the state of Delaware, but her businesses are in Delaware. And so I think that's where we're going to have to, figure out, is it fair to adjudicate this case in Delaware against Candace Owens? So we have to deal with fairness factors such as, does she have the ability to make it to Delaware to properly, hear her case? I would say she would. I'd say, she has plenty of money and things of that nature to get on a flight from Nashville to Delaware to attend any hearings and stuff. So if we're dealing with fairness, I believe that the court would have proper personal jurisdiction over her. I believe that's how I wasn't able to look at the opposition, but they likely framed it that way as well. And with respect to the venue, a lot of that is going to be what we discussed. And then forum nonconvenience, I wanted to touch on this.
Okay.
When you make a forum nonconvenience argument, you're essentially saying to the court that there's a more convenient forum to hear this in. She's pointing to Tennessee. Right. However, here's the caveat with forum nonconvenience. The case, if the judge does dismiss the case based on forum nonconvenience, he expects you to not dispute anything in the Tennessee court, which would mean that if the judge does grant for forum nonconvenience and this case gets moved to Tennessee, Candace Owens would not be expected to dispute jurisdiction, and she would be expected to submit to the case. If she doesn't, that's when the court in Delaware, that case could be refiled in Delaware. Then the lawyers for Macron can say she didn't properly avail herself as she said she would in Tennessee. So that she's kind of implying that there is a proper forum. It's just not in Delaware. It's in Tennessee. So that's just an interesting caveat.
Okay. No, that's super interesting. Okay. So I pulled up the lawsuit against Leeds, which was the USA Today. She says Candace Owens in her individual capacity and Candace Owens LLC. So
could you scroll up on that document too? I just would like to see state of Delaware. Yeah, you could potentially make an argument then that, she does have specific minimum contacts with the state of Delaware to the point that she's brought previous actions in this state. Now, whether that's going to be a hugely successful argument, I'm not sure, because a lot of it's going to be adjudicating the fairness of actually holding, Candace Owens as a defendant in a Delaware court. I do believe providing this document would be evidence that it would be fair because she's done previous lawsuits there. So it's a great point you bring up.
Right. And that's all I was just wondering. I think that I feel like what you've already laid out was sufficient enough in, legal JWhit's mind, pre-K mind. So I think it's probably sufficient, but I was just wondering if they needed like the icing on the cake or they needed a little bit of straw to break their camel's back. I thought the fact that you've already sued people from Delaware before, like I'm pretty sure there's probably others because she's kind of litigious. What if her using the business registered there? I'm not 100% certain what you mean there. Do you get that, Nick?
Yeah, I think basically the question's asking, can Candace Owens have her case properly, or can Macron's adjudicate the case against Candace Owens as a human being in Delaware based on the businesses being registered there? And as we discussed, if she's, still making contacts with these businesses, if she's on the registration information, she's previously brought lawsuits in the state of Delaware in conjunction with her business, I believe that could be, used as evidence or of it is fair to adjudicate the case in Delaware, and that's the proper forum.
I got you. Okay. Hey, let's take a quick turn off because there's a question here. I've seen people sued by doctors for posting their bad plastic surgery results and naming the doctor on websites. Same for negative reviews on Google. So that might be. I know that there's a lot of discussion going on about defamation and libel in the chat, but what about this situation where somebody doesn't like the business and give a bad Yelp review or a bad Google review?
Indeed. No, this is a really common scenario. Now, each state is different on how they protect individuals' ability to participate in matters of public opinion or public concern. So here in California, we definitely have a doctrine that protects for public participation. So, if somebody goes to Yelp and says this restaurant undercooked my food, or this lawyer did a bad job servicing me, or this doctor didn't do a good job, those are considered matters of public concern, really because they somewhat relate to economic output and productivity. And then, when you're posting that type of information, it's also good for the public to know, hey, don't go to this provider because they don't provide quality products as much. And so that's an example of public participation. So what an anti-SLAPP suit is, and I've covered this in my in another video, is it's a strategic lawsuit against public participation. In California, we had an issue years ago where essentially, if somebody said something about a celebrity or said something about a major business, that business would bring a lawsuit against them. And then with respect to the stress and discovery available with the lawsuit, it scared a lot of people and chilled their speech. So they didn't actively participate in matters of public concern. And so what the legislature did is they passed a law, an anti-SLAPP law, that says if you are bringing a lawsuit for the purpose of, suppressing an individual's ability to participate in matters of public concern or filing a lawsuit or anything of that nature, we can then, we have procedures against that basically. Sure. And so a defendant in a situation like that could move to essentially dismiss/strike a complaint that's really trying to suppress their public participation. So in a case like this with a doctor, how I'd quickly frame it, we have an individual who files, puts this bad, surgery on their Facebook, whatever you name it. The doctor brings a lawsuit against them. That former patient is now the defendant. That defendant then brings an anti-SLAPP motion and says, I'm just participating in matters of public concern, strike that complaint, dismiss it. And if I'm successful, I also get my attorney's fees. And so, yeah, that's how you protect matters of public participation. But not all states actually have legislation like this. So for those doctors or big businesses, it is a little bit more intimidating for some people to post negative reviews at times.
Okay. No, I appreciate it. All right, let's jump back to my questions here. What concrete attributable evidence or damages would the Macrons need to prove for their claim to succeed?
Yeah. So when it comes to the Macrons, obviously damages is the final legal element you generally have to prove for all claims. So when we're speaking of reputational harm, generally you want to show like, hey, I've lost the ability to gain future employment. I've lost the ability to have future contracts. I've lost the, ability to engage in public speaking engagements. Those are going to be the types of evidence or reputational harm that the Macrons are going to show. So can the Macrons successfully show that they've lost out on certain employment opportunities or contracts, or other, aspects of that nature? And in my kind of just preliminary evaluation, I do believe that's going to be difficult because, they are public figures. And when I'm saying public, they're really government too in that aspect.
President,
it's not like they're just like famous actors or anything that are French. And so with that, it's like, it's kind of difficult to conceive of a government official arguing for loss of private employment opportunities, and then I don't really think you can plausibly say you've lost out on public employment opportunities, such as, hey, I've lost out on the ability to be president again. I'm not so sure that's very, plausible. With respect to the financial damages, I don't really know what financial damages they could plead what contracts did they lose? So I think that's a potential weak point that maybe Candace Owens should try to focus on what did they lose? What are they saying they lost?
I don't know. I think I've lost the opportunity to be president because of this. I can sue her because, you know what? I can't run for president now because of this crazy shenanigans. She's accused everybody on the planet of being responsible for it. So therefore, I too am now filing suit.
Hey,
go ahead.
Well, I was going to say, like, we could run down that rabbit hole, but I would just be like, if I were representing Candace Owens in a situation like this, I would say, well, it's not my causation that led to your loss of presidential dreams. Maybe your own commenting on it. You know what I mean? Like the causation is who really caused it, because causation's huge, Wow. And so
I see what you did there. Dang it.
Yeah. Who caused it? You or Candace Owens, I suppose, that's going to be ultimately what you'd run into.
Nick, I don't like that answer, man. Now I'm a little bit upset now, man.
You voluntarily inserted yourself in some ways. I hate to say it.
Nobody told me to, right? Hey, what about piercing the corporate veil? Do you think they'll be able to separate the person, Candace, from the business? Or is that even necessary in this regard? What do you think? Or is that a thing?
Yeah, no, that's a great question too. Because when it comes to piercing the corporate veil, generally the only reason you're going to do that, and each state is different on how they govern this procedure. Sure. But you generally have to show tortious conduct by the business itself that is then attributable to one of the members or owners. And here that would be Candace Owens. Candace Owens, as I understand, has been sued individually on this. So there is no reason to really, quote, pierce the corporate veil, because if you pierced it, on the other side of it's going to be Candace Owens, and she's already named in the lawsuit. And so, that's just to me
surprise.
Yeah, exactly. So, and then do you think they'll be able to separate the personal Candace from the business Candace? Yeah, I do. I think, you might be able to, recover against, get a judgment against both of them. Ultimately, you're only going to recover a single harm, but I think you could treat them as legally different and move forward.
Okay. Hey, Nick, do you like spy movies at all?
I used to watch when I was young, like the Spy Kids movie, and then the James Bond. I've seen a couple of those movies.
Okay, there we go. Okay, so here's a question, Nick. Ask Nick if there was really a hit on Candace by the Macrons. Wouldn't the lawsuit have been updated, or wouldn't we know some tangible way that there was a real lawsuit? I'm sorry, a real international hit put out on Candace, if in fact it had happened?
Yeah, and so with respect to hit jobs being put out on people, Candace has accused a couple, or the Macrons, of initiating a couple hit jobs on different individuals around the world. And so, in fact, based on my reading of the complaint, one of the theories upon which the Macrons are trying to recover is not only you called Bridget Macron a man, they're also trying to recover on the basis that Candace Owens has accused them of serious criminal misconduct, such as ordering the assassinations of other individuals, which is serious criminal accusations. And so that's defamation per se, because you're accusing another of serious criminal conduct. And so I don't believe that the complaint mentions specifically ordering any type of alleged assassination of her. It more so relates to ordering assassinations of others and how that still is implicated in serious criminal conduct. So, if they want to amend and add that Candace said that she was, or that they were going to do that to her herself, you can do that. But ultimately, you've already pled a sufficient allegation related to a serious criminal accusation of ordering an assassination. So just recover on that, maybe.
I got you. Well, she has, since the case has started and since the Charlie Kirk saga has begun, she has intimated that the French have put a hit out on her. So this is post, since the lawsuit was in play, she has come up with this story that, an international hit team was put out on her. It's the craziest story, man. That's why I ask you, do you like spy movies? Because it sounds like the way it reads is like an old Tom Clancy counterterrorism spy movie.
And then too, I mean, Candace Owens always can hide behind that term hit, right? She can say, "Oh, well, when I said hit, I didn't mean hitman.
Well, she said assassination."
Okay,
she said it.
Okay, then that actually involves alleged murder accusation. So that crosses the line. But if she just used the term hit, she could try to play it like, "Oh, I just meant they were putting out a hit on me on YouTube or through the public media," versus not, assassination. But clearly, you indicated different.
She did say assassination. It's a crazy story, man. You're just like, wait, hold on. You actually took that seriously? That's crazy. How likely is a case like this would survive a motion to dismiss and reach discovery phase? So it's kind of like two questions there. What from your understanding, how likely do you think it'll survive the dismissal? And then if so, get to discovery?
I think so. It's there's no guarantees in law, so I always have to state that first. But when it comes to a motion to dismiss like this, I saw the grounds. None of them are based on anti-SLAPP theories. So while the language is dressed up in, "Oh, the Macrons are trying to suppress my ability to participate in a matter commenting on a public official or a public concern," she writes a lot of her allegations to sound like anti-SLAPP objections. However, when you really break down the assertions, it comes back down to personal jurisdiction, venue, forum nonconvenience. As we discussed earlier, I believe that the court has sufficient personal jurisdiction over Candace because she has sufficient minimum contacts with the state, and it wouldn't be fundamentally constitutionally unfair to hold her there. She can always buy a ticket. She's got the wealth and the resources to, do that. It's not like she's some, average person in that sense. So I think she can make it there fine. And then could I see the rest of the question again?
Oh yeah, I apologize. Sorry about that.
And then survive the motion. Yeah, I think it's greater than 50%, I'll say, because ultimately, when we're dealing with anti-SLAPP, generally the court is going to have an evidentiary hearing and try to quickly determine the merits of the case. Here, we're not determining the merits of the case in any way at all. So the court is in no way trying to look at, okay, is it true? Is it not true? All they want to determine is, do we have personal jurisdiction, venue, and all of that? I think it's going to survive those arguments. I mean, that's just kind of my professional opinion. I could very well be wrong for some reason. So I believe it's greater than 50%. And if it survives the motion to dismiss, then Candace Owens will be ordered to file an answer in response to the complaint. And when she files an answer, that's when the discovery phase will start.
Got it. So when they file, okay, so if I'm not mistaken, I think it's the 6th of January. So the dismissal determination will come out the 6th of January. Let's just say it comes back, dismissal's thrown out. So that day they have to answer, they have to submit an answer, and then they got to start horse trading for the discovery process.
Yeah. So generally, like when lawyers are filing responses to complaints, because the Macrons have brought a complaint. So now if Owens loses her motions to dismiss and is ordered to file an answer, she'll have the option, or she's going to have to file an answer, but then she can also evaluate, do I have my own claims against the Macrons? Does she want to sue back for defamation of some sort? Are there any plausible theories that she, would want to come up with as to why she, because really it's like, you don't want to just assert an answer. You want to come back with hey, we got stuff on you too, so let's raise the stakes a little bit. So I can see Candace Owens filing a cross complaint or a counterclaim at the time she files her answer to, which she'll be forced to do since it will be substantially factually related to what the Macrons are stating.
For sure.
And then after that stage, the discovery procedure is governed by like state law, so the code. And so, it'll just be who's going to prepare the discovery first and serve it on the other party. Will it be Macron's attorneys? Will it be Candace Owens' attorneys? Maybe at the time they're preparing the answer and the counterclaim, maybe there's some associates at the firm who they're going to have to prepare, requests for production of documents, interrogatories, requests for admissions, notice deposition dates. We want to depose, Candace Owens herself. We want to depose George Farmer. We want to depose, let's say there's another business person registered on that, her business, document or something like that in Delaware.
For sure.
Let's depose or, subpoena, that individual as well. And let's bring them into the case too.
Wow. Okay. So speaking of that, what role can court-ordered versus private DNA testing play in proving or refuting public claims, and what privacy limits apply? We kind of talked about that, but I just want to talk directly because that seems like everybody's like, well, just do a DNA test, do a DNA test, and that would settle it. But I don't know if that's necessarily true.
I agree. Yeah, I agree with that analysis because ultimately, I'm going to have a video coming up on this in a few days, which should, state this more clearly. But, when we're dealing with DNA testing, that's one of the most invasive procedures that can be performed because, the court is a governmental branch. And so when we're dealing, when we talk about government conspiracies and all this, well, government action can occur through courts too. And so imagine the government ordering you to submit to a DNA test. And they're going to have access to that information, how it's retained, and things of that nature. And so when we're dealing with like the Macrons who are seeking to protect their reputational harm, imagine if before you file suit, you're an average person or another public figure, and you're thinking, well, somebody said something, about me in this context. Now, if I file this defamation cause of action against this person, the court's going to order me to a DNA test. So that can be, again, the most extremely invasive because it reveals a lot of, again, family ancestry, that maybe people don't want to know, family illnesses and stuff like that. You can find out certain medical information of people. And so that is a huge privacy concern to deal with DNA. And are there available alternative methods to prove what we need to prove? Can we get certain medical documents that show, this individual is a woman or a man? And I'm sure there are, I think the reason a lot of like the Candace Owens followers they're harping on this DNA test is because really it gives them an excuse to ignore all the other evidence. Why not just ignore all the other evidence and focus on this DNA test that we know is extremely invasive? Because maybe you want to bring humiliation upon the Macrons. You want to subject them to the utmost privacy invasion on sitting down to a DNA test, and that could be humiliating. And so I think that's the goal of a lot of the followers, is to bring very humiliating aspect to it. But is it too invasive to actually to be given? I would say, yeah, because I think there's alternative discovery available to gather that. I think the issue is you're dealing with Candace Owens followers who really don't want to believe any evidence that goes against their own narrative. Let's say we have a private DNA test tomorrow, right, JWhit? Let's hire a DNA, and we get the results, right? If that result doesn't come back with what something Candace Owens want, Candace Owens could have been sitting in the dang room. She's still going to deny what occurred and that, when I wasn't looking, he switched something. It's going to be something every time. And so that's just the issue in the nature of dealing with people that don't want to accept consequences for their actions. Is, it doesn't matter what happens. I think the court could order it. It could be done privately, but ultimately it's going to come back to some conspiracy about a cover up involving somebody somewhere in the chain, whether it's the court, the examiner, you name it. And hell, they might even one day turn around and say Owens herself accepted a bunch of money, and then she said she's the one that she endorsed the test as being false so she could get money. You don't know what these people come up with.
That actually wait. No, that would actually work. I hate to say it. I actually could see that one happening.
Yeah,
I can see that one. I
it
can
was
totally see that one.
dismissed because Candace Owens got paid under the table and, stuff like that.
Or Candace Owens denied it so she can make more money. And I hate to say it, but I can see that one happening. Dog, you've given her 5 more videos, by the way. Way to go, Nick. Great job.
Yeah.
You gave her 5 more videos.
Just deny all the evidence.
Well, there you go. No, and I agree. I don't think there's any way to satiate the bloodlust of Cantifa. They want blood. And I mean, literally they want blood, and figuratively they want blood. But they're not going to be happy no matter what it is. Whatever the results are, they just want to be right no matter what. Their narrative to continue to be propagated. Go ahead.
And well, when it comes to these DNA tests too, because this is scientific evidence, so generally lay people can't give like their opinion related to certain scientific evidence. So we would need an expert to come on and authenticate evidence of this type to say, hey, this is real and authentic, and this was a properly done exam. But I mean, as you may be seen in like different cases, you can have experts on each side, right? I was once a juror in a case where we were dealing with a lower back injury, and we had an expert brought in to say, hey, the lower back injury affected the woman this way. And another expert came in and said, no, the injury actually affected her this way. And so when you get these experts that conflict with each other, then it's just a matter of, all right, who's the jury there and who are they going to believe? And so that's why, when it comes to jury selection, you don't want people that are just blind to the truth. And they're so, made up in their minds, whether they support Candace Owens or whatever it is, that they can't, properly, independently and reasonably decide the case.
No, I think that's an excellent point. And I've mentioned this before. I think that there's probably either a history of illness in Brigitte Macron's family that would probably come up to bear. That means, her daughters or grandchildren all know, everybody now knows that they have this particular illness, or Brigitte Macron is intersex. And that's going to come out, and, that information will get spread out. So I think that, but they have to know that this is they're going to come to this place where they may have to do a DNA test. And I'm like, well, they must be either the most ridiculous, foolish people on the planet to put themselves in this crosshairs, or she really is a woman. Otherwise, it would have been silly to do this, and I know Nick is going to sue my socks off. Why would I put myself in a position? Beat my socks off if I sue him. Why would I do that? Why would I put myself in that position? I know I'm going to lose. But I think they know that they're going to win. So anyway, that's just my little thought on that one, though.
Yeah, I think, when it comes to ordering a DNA test, that I would, if I were representing the Macrons, I would have a strong opposition, and I would couch that in privacy concerns. And I would say, you're trying to get the government to order my client's DNA, and you want to retain that information and all of the stuff that comes with it. And I would argue you're only doing it as a scorched earth tactic to humiliate my client for bringing this lawsuit. And really, you're going to chill any type of defamation case around the globe, because basically now we can just accuse, you see all this like people kind of androgynous dressed or something like that, dressed, and so, they're a man or they're a woman. And now, if they bring a defamation suit of some sort, or, a claim, suddenly a DNA test is on the table. Would Candace Owens want to submit to a certain DNA test? I'm not so sure she would be so thrilled for that type of court-ordered discovery either.
No, she definitely would not. I think that was all of my questions. I did have one more question. I saw another one pop up here as well. Nick, it does at all, as we're talking about like damages, the Macrons could talk about damages. Do they ever take into effect the family? Like, my wife, my kids, my grandchildren are all being negatively impacted because Nick is suing me and saying that what he's saying about me, or what Nick has said about me, I apologize, what Nick has said about me in defaming me is impacting my wife, my kids, my grandchildren, my dog, all that kind of stuff like that. Like, does that ever play into it, or is it just simply, Jason, is on you, not the halo effect?
Yeah, generally when we're dealing with damages, you have to plead damages that you yourself suffered, not the damages that other people suffered. If other
I got
people
you.
suffered reputational harm, they would be expected to bring, why this false statement of fact, about them published to another, and so I think that type of claim would break down if it was related to like the grandchild, because I'm not so sure they would meet all the elements of the claim, and the damages would have to be more personal to that individual. Otherwise,
Right.
it's almost like Brigitte Macron's coming in as a plaintiff representing all these other people, and that's not exactly the way the case would work.
I got you. All right. So the other question that popped up just a second ago, do we know when the case starts? So looking here, and I'll pull it in just to share with y'all. All right. So what I have here is the infamous docket. And if you've been following me, I'll leave the link to it down in the chat as well. And I have a file, a Google Doc, where I've been keeping up with all things Macron, all things Tyler Robinson, all things Candace Owens lawsuits. And so at the current moment, we're supposed to, it's January 9th. Okay, so January 9th, the judge is supposed to rule on the dismissal of the case. And
or is that the date that's of the file, or the reply is due, or when the order is being given? I thought that was the reply due date.
All right, let me read it. Order date docket, December 13th, 2025. Order signed, Renee Sheldon. So ordered. Stipulation and proposed order governing word limit, and deadline for the reply in support of the motion to dismiss, reply 7,500 words, January 9th. Okay, so that means that they got till January 9th.
Yes.
My bad.
Yeah, to answer the question kind of as I understand it, currently there is no trial date set. Right now, the parties are just resolving their pleadings before the case enters into discovery. After the parties resolve their pleadings, the court will set a date typically for some type of case management conference where they can basically say, hey, is this case moving along fine? And they'll also, at that case management conference, typically set like a trial date and, a trial readiness conference of some sort in the future. Now, these trial dates are set sometimes a year and a half in advance. So I don't expect this case to even have a trial date until maybe like early to mid 2027. So that's when like a trial date is realistically expected to be set. And the whole time in between there, the parties will just be gathering evidence against each other in discovery and trying to settle the case before it actually reaches a trial.
Okay, I'm glad you brought that up because, all right, you got to put on your fortune teller hat, get your magic 8-ball. Now, this person just says, Candace will settle out of court and say she was forced to. Should be obvious. What do you think about that?
Hey, it depends on how you want to word the settlement agreement. If you're the Macrons, are you concerned about Candace Owens jumping on her podcast and saying, I was forced to settle for X number of dollars? I don't know if it's going to be $1 million, 10 million, 100 million, you name it, who knows?
A lot of million. Right.
But the thing is like, if you're willing to just like take the money and then accept the fact, hey, she's going to jump on her podcast and talk about she was forced to, and this was coercive, then you can live and sleep at night knowing that, hey, you got the settlement, you got somewhat of a win in this case. Now just move on with your life and let it kind of go. You could also add language into the settlement agreement, such as a non-disparagement clause. After this settlement occurs, you are not to state anything disparaging about plaintiffs in any context, including such as stating you were forced into this settlement agreement. So that's where the parties have to, but non-disparagement clauses, if you violate them, then you open up the fact that your case could be litigated again. So sometimes they're difficult clauses to include. So do the Macrons want to include any type of non-disparagement clause? If so, why? I'm not so sure. I'd be interested to kind of hear their thoughts on that.
Okay. So let me ask you this question. Could the Macrons say, you know what? I feel like they have her over a barrel. So I do believe that the Macrons are in the catbird seat as it relates to how this is going to play out, because they can just say, hey, we're not going to settle for anything. Whatever you want to discover, that's fine. We want to take this to trial, and we're going to drag this out and just waste your time and then just really ruin your life with time wasting. No, I believe they could do it. Or you take down every video that you've done about us. We want all of the money that you've gained from those videos you've done about us, and you can't do any more moving into the future.
You could stipulate to that in some type of settlement agreement. You could stipulate to really anything you want in some sense for conduct for purposes of dismissing the complaint. So if you want to see the retraction of videos, you might even write in, you're going to apologize publicly on your platform and state that these, statements were false and I knew they were false or recklessly disregarded the truth. Like, I just looking back on the Alex Jones, I know he was apologizing a lot, but I think that might have came to a judgment against him. So if you're dealing with a settlement, it's like, what do you want to go for? Are you more concerned with the retraction and the issuance of an apology? Are you more concerned with the recovery of money that compensates you for reputational harm? What does each litigant want to get out of this?
Okay. Remember that movie Trading Places with Eddie Murphy and Bill Murray? Is it Bill Murray? And they were one was a bum, the other one was a financial analyst, and they swapped places, and the two guys had bet $1 that they could ruin their lives. And so maybe the Macrons just say, you know what, we just wanted you to apologize and take all your videos down, and they'll just take $1 because they just wanted to get her groveling at their feet. I think this is interesting in light of what we were talking about before. We don't have to bring this up, but somebody just said, I saw her Facebook post today. She basically had a sad emoji saying everybody's going to sue her. She's worried.
That would
brought it on
indicate
yourself.
She's worried, yeah, for sure.
Yeah, I mean, you brought it on yourself. I had mentioned to somebody earlier. You do realize that pretty much all of Candace's, because she builds a better rogues gallery than Batman does, right? So all of her rogues are because of something that she has said. I can't think of anybody who's against Candace because she's black or because she's young or a woman. Everybody's against Candace because of something that she said. So she has created her own rogues gallery. She's created all of her enemies from the things that she says, in my opinion.
And I mean, too, like, I wanted to touch on the fact of like going over some of the Macron's aspects on, some of their defamatory claims and if they're going to be successful. The question is going to be this. I think the criminal conduct satisfies because that would qualify as defamation per se. But is it inherently reputationally harmful to call someone a man or a woman when they're not? I'm not so sure. And I think it's contextually dependent on the society in which you live and, the jury you get. Because, if we're in like some very conservative state, maybe calling a woman a man is much more reputationally harmful than if you live in some liberal state, that it's not so offensive. If I called you, for example, or you called me, transsexual, homosexual, or something, of that nature, is that reputationally harmful? I'm not so sure. If you're in really conservative states, yeah, like, I mean, if you're in like Saudi Arabia, if that's known as your reputation, you might not last much longer, Right. But if you're in California, it's not that reputationally harmful. And so like, that's also kind of an interesting aspect is Bridget Macron's just, you called me a man, actually inherently reputationally harmful or defamatory? That's not so clear.
Interesting. Okay. So would you say that's if I had to ask you, what are some ways that the Macrons could win this lawsuit or the Macrons could lose this lawsuit? Would you put that in the category they could probably lose it because it's not really that concrete?
I would say that the way I would challenge it if I were Candace Owens' attorney, first thing I would attack each element. So I'm going to attack that this statement that you called her a man is not defamatory. There's no jury that's going to say, oh yeah, calling a woman a man is, defamation. It's defamatory to do that. Now, I mean, there's some juries that very well could say that, if you're in like maybe like Alabama or Mississippi or something. Right. Yeah. That could be reputationally harmful, and a jury would absolutely, oh my gosh, how could you question that? But if you're in California, they may be like, this is why you're suing somebody, so that's going to be kind of like a tension because we're in Delaware. What's Delaware going to say about that? So I think that's the first layer on how I would attack it. Is I'm not so sure that calling a woman a man is harmful in that sense. And then two, when it comes to the causation aspect, if I were Candace Owens' attorneys, I would say, it's not Candace Owens' rhetoric that caused you reputational harm for that statement. There were other other rumors going on all over the internet that actually served more for your reputational harm. So I would be trying to make an argument that, look, it wasn't just me that was involved. It was others that were involved. And, I'm just one participant of many. So you can't hold all the reputational harm as a result of my own action, like my actions alone. I was joining like a tidal force of this content, I guess. And then the damages.
Okay, then I'm trying my best to be a legal expert. I'm gonna push back and say, but you had the largest platform. All those other things were rumors, on the third page of a Google search. You, however, were the loudest voice, and you brought all that stuff to the front. And now everybody's talking about it because of you, not because of the 25 other rumors that were on the back of the very last page of a Google search. You are the reason why, would be my pushback. How'd I do?
Yeah, I think that's a great pushback. And I think I think that shows evidence.
I'm taking the bar.
Yeah. And because that's the thing it's because ultimately it would be unfair and unjust to hold accountable one person for a widespread rumor that a lot of people engaged in. Justice should be more individualized against the offenders and for people who need it. And so that would have to be the approach. Is you would want to isolate that. Look, this was a result of Candace Owens' conduct, not a result of other individuals' conduct.
I can dig it. What is the better strategy when bringing defamation suits regarding TPUSA before or after the murder trial?
Oh, that's a good question. Yeah.
Amethyst has some great questions. Shout out to Amethyst.
Yeah, let me think about that. The thing is it like after the murder trial, there's potentially certain, statements you could use in the case. I doubt Candace herself gets called into the murder trial, but if Candace was under oath in this murder trial, certain statements that she makes under oath could be, used later in another type of proceeding, if necessary. So that's kind of maybe one advantage you could get is if she said something at the Tyler Robinson trial, related to like this whole, assassination plot of foreign governments and others.
For sure.
And then if a lawyer asked her, well, did you have any personal knowledge of these statements at the time you made them? And she goes, no. Well, that type of statement could be used later in a proceeding regarding defamation to establish, hey, you had reckless disregard for the truth or, knowledge of falsity, and you continued anyway. Right. So that's where you can use previous statements under oath and have them admitted in other proceedings.
I like that. Okay. Shout out to Amethyst. Thank you, love. All right. At what point does she cross the line and begin to become a national security issue? Has that ever happened where a private citizen becomes a national security issue?
Yeah, I would say this. I'm not so sure Candace Owens is a national security issue at this point. That's a pretty funny question, like the way it's posed, because like when we're dealing with issues of national security, it's almost like to the point of trying to stabilize civil society and things, or like, there's a massive threat of like an incoming armed invasion of a foreign nation or something. So that's more reserved for the category of national security threats. I would argue that Candace Owens is simply a public figure who's stating comments related to, yes, a foreign official, but just because those comments relate to a foreign official and it could cause, a loss of goodwill maybe between the United States and France because you have this famous podcaster who's American stating bad things about a foreign French official. If that brings any reputational like lack of goodwill between those nations, that's not necessarily a national security issue. And the French and Americans, we have a lot of good relations anyway outside of Candace Owens. I doubt Candace Owens herself is going to ruin an entire 200 plus year history of, relationships.
Right.
So yeah, I would just say like, no, think of it like this. After 9/11, do you think anything Candace Owens has said rises to a level of security after 9/11? I wouldn't say so. It's not like we're threatening wars upon other nations for the purposes of stopping her conduct.
Okay. So let me add to that then. Let me add to that. Can she get in trouble for telling military people to go AWOL?
Yeah, no, that's interesting. I've never. Well, I'm not. Yeah, well, so I guess like AWOL's. What's the official acronym for AWOL?
Absent without leave.
Yes. Interestingly enough, there's a couple of those that have happened in like war and stuff like that. But yeah, no, when you're telling people to go AWOL, ultimately those military officials have the option to not listen to you, and those military officials, you don't have any authority over them. So it's just like if I said to some I live in San Diego, we got a huge naval base. If I was out, if I was out one night and I saw like one of our sailors or something like that, and I was like, hey man, I want you to go AWOL. It's not like I could be, in trouble or arrested. Really, the responsibility is going to be on that sailor ignoring somebody that doesn't have authority over him. And he's been taught properly to do that. So yeah, I don't think she can get in trouble for saying that. It just makes her lose a lot of credibility with people who actually understand like the way military authority structure works.
Okay. That's dope. Now, what about that jury pool? As relates to, and I guess in both cases, her own case with the Macrons or the Tyler Robinson case, can she get in trouble for muddying the waters or causing issues as it relates to the jury?
Yes. So when I doubt that she could really kind of get in trouble. Now, if she starts contacting jurors and things of that nature, that are identifiable, now that could become an issue. But with respect to just making public comments on public issues that, a potential juror later could see, and look up, all the jurors are generally, you're ordered by the judge not to look up information outside of the case and to use what the lawyers in front of you give you as factual evidence. Don't go home looking up stuff on your phone and computer. Like they generally tell you that, and you should follow it. I'm not so sure every juror ever does. But yeah, so when it comes to muddying a jury pool, I think the first question is this. Do you think Candace Owens has actually, her statements have reached everybody? If you took the state of Utah and asked them, how many of you have ever heard of Candace Owens? I'm not sure you would get back 50% answers.
Really?
I think less than half of people actually probably follow her or have heard it. So immediately, I think you already got a jury that they're like, who is this? I've never heard of these allegations or this woman. They maybe have heard of like the fallout and like, oh, I heard of something about an assassination plot, maybe he wasn't involved. Yeah, sure. But it's not like they're going to attribute that to Candace Owens. But then ultimately too, that's where the prosecutors have to, hey, as a prosecutor, you have a duty to prove a case beyond a reasonable doubt. And if you can't do that and the defendant is able to somehow come up with something, well, ultimately, then you should have had better evidence before you brought the criminal case too. And so I would say that to the prosecutors is just like, do your job, prove this case beyond a reasonable doubt, show all of this conspiracy nonsense is exactly that nonsense. And and then with the jury, I'm not so sure all these jurors have actually heard of all Candace Owens and all of these theories. And I think you could find some fair, independent jurors.
Okay. All right. Well, I would have thought that more people have been sullied by her, but I guess in retrospect, I can give you that. I can give you 50%. I'll give you that for sure. Lots of good people are enjoying this conversation, Nick. Thank you.
If I may too, JWhit, you ever heard that thing where it's like, it's sad. It's like 1 in 5 Americans can't point out the United States on a global map or something like that. So it's like, how many of you think people are following some of this trial work going on in Utah? Like, I'm not so sure of the rumors. People definitely got a lot of other things going on. So that was the only reason I'm not so concerned about that. I think the prosecutors and defense can get it done.
Okay. Well, I got you. Now, she has mentioned that she's talked to like Tyler Robinson's family. She talked to Lance Twiggs' family and others of that nature. So what constitutes witness tampering in your understanding?
So I've always thought of witness tampering as going against that particular defendant. So like if Tyler Robinson or his lawyers kind of reached out to certain witnesses that would be used against him, that would be the more prime example to focus on. But when we're dealing with a non-party like Candace Owens initiating contact with potential witnesses like family members of Tyler Robinson, she definitely, has a right to, freedom of speech and freedom of association. So you can't tell her not to communicate with certain people. And if those witnesses also are willing to communicate with her, that's their right as well. So you can't really refrain any type of contact. Now, I mean, it would be wrongful, and I'd have to look in more into the consequences. If you instructed them to lie under oath, that might be a real problem. You're still expected, if you speak with Candace Owens, if you get called as a witness, you're still expected to speak under oath. And so you can't just spread lies that if you're instructed to do that. So.
Okay. No. See, I mean, you're building a little fan base over here, Nick.
Hey, no, thank you very much.
All right. Let's go back to juries. And of course, you have the normal run-of-the-mill jury, which is the jury that comes in every day, 9 o'clock, they leave at 5 o'clock, and they get $25, $30 a day, whatever that piddly amount. But then there's the sequestered jury. What are the odds, just in your mind, and again, where this is no statement of fact, what are the odds that the jury would be sequestered in your mind?
That's a great question. I'll say this, in my own practice, I have a lot more experience in civil cases than I do criminal. I mean, I've done some criminal, appearances. I've got knowledge in my criminal procedural law and substantive law. This is an advanced criminal procedural question that when we're dealing with the sequestering of a jury, I'm not really exactly sure of all the legal standards that it would take. I guess, just theorizing, you'd probably want to sequester them if you're concerned about them gaining knowledge improperly. The only issue is this, if you have a juror, and imagine if you're a viewer right now watching this, if you're a juror, do you want the court to order you to stay in a hotel, or, you can't get on your phone in certain ways? I mean, they're already going to tell you don't get on your phone and look up things anyway. Wow. Yeah. So it's I'm not so sure the benefit you're gaining by trying to sequester a jury and make them stay somewhere isolated and go back and forth. It's possible, I'm not going to rule it out or anything. I'm just not extremely knowledgeable on the standards it would take to get that relief or that sequestering.
So you've never sequestered a jury? No,
I'm not. I've heard of I've heard of that, on a couple cases, some high profile criminal cases.
For sure.
But no, I don't really know the legal standards that would go in, why a judge would order the sequestering of a jury, because, jurors are people too. They want freedom. They want to go home to their families. And so you got to override that interest for a really good reason. And I don't know the legal reason to do so, as I speak to you.
No, I got you. Okay. Just for laughs and giggles, we're co-counsel, and there's a gag order on everybody related to the case at this current moment. And now they haven't pared down everybody who's in it, but do they send out a notice and say, hey, we're thinking about maybe calling you as a witness. Please don't speak on this topic. Is that how they do it?
Oh, when it comes to gag orders, I'd have to look up some of the legal standards related to those and why you would issue them, because gag orders ultimately are suppressing individuals' freedom of speech rights, and it's government imposed and court ordered. And so you have to have really good reasons to override somebody's First Amendment protections. So yeah, I'm not really sure on how, to answer that question, other than to kind of look at some of the issues we would have to evaluate.
Okay. Well, okay. Because I was actually going to throw out a theory to keep Candace from running her mouth. I was going to say, if we already know that we have and this is what I was just thinking again, this is probably not how it works. We already know that there's a list of jurors that we're going to be, witnesses that we're going to be reaching out to. And we just say, hey, we're just going to ask you not to speak on this topic, whatever like that. And we tap Candace as one of those jurors. She would not be able to speak on this topic anymore. And even though she might fight it or not want to, whatever, but she's placed under the gag order for the time being. Is that correct? Or is that how it works?
Yeah, no, I wouldn't be able to give you a straight answer on that as ordering witnesses not to speak on information. It's a controversial issue because you're implicating First Amendment rights.
Yeah. Wait, desperately looking for how to get Candace Owens in trouble. I'm not saying I was trying to get her in trouble. I was just going to say, hey, she's under the gag order. She has to be quiet. That was all I was doing. That's all I was doing. Look,
and that's the thing is, like, if you put Candace Owens under a gag order, I mean, it would be wrong for her to violate by going on her podcast. But imagine she went on her podcast and was like pleading that, look, the government's trying to keep me quiet and I can't say anything. I mean, she would almost use it as an endorsement
of bludgeon, yeah.
Like, oh, they really don't want the truth to get out type of, so it's like, that's kind of the issue when the government starts trying to suppress speech is sometimes the people being suppressed will actually use that as a rallying point.
That's fair. That's fair. All right. So we talked about all of that good jazz and you told me, where do you see the Macron case going? Do you see it passing the dismissal or getting thrown out?
I see right now, based on my evaluation, I do believe that it'll survive the motion to dismiss. I give it greater than a 50% chance, but obviously I'm not going to guarantee 100% chance.
Okay.
And then with, respect to it surviving, I could see it entering into discovery, but here's the issue. If it passes this motion to dismiss, I think it will either settle quickly or go on for a while. Because a lot of when it comes to these, like if you ever watch some of these cases in the NFL, it gets involved in, when a litigant beats the NFL in the pleading stages, the NFL will quickly settle after. Just think back to the Colin Kaepernick case. Colin Kaepernick brought, causes of action against the NFL, and he survived his motion to dismiss stage. So the NFL lost at that stage of litigation. And as soon as the case was advancing to discovery, the NFL wiped their hands and paid, reportedly $60 million to avoid discovery because they really don't want that information to get out. And that's how much they value, keeping private a lot of their internal communications and business information.
Okay. So it's fair to say then, because someone did ask about the dismissal, filing a dismissal as like a strategy, it is fair to say then that filing a dismissal is a strategy to determine how the temperature or the likelihood that the court would allow this to go any further. And then from there, let's go ahead and settle this out before we even get that far. Cause I know the court is going to hear this case. Is that fair?
Well, so for purposes of this motion to dismiss, Candace Owens has only contested personal jurisdiction, venue, and requested forum non-convenience. And so, trying to propose an alternative forum. There's nothing else being tested by this motion to dismiss. This motion to dismiss does not concern the substantive allegations. It does not concern the merits. So Candace Owens isn't even questioning the merits. She is purely questioning, is this the proper forum? And so where that question gets resolved, and that this is the proper forum, that's when, it'll move to discovery so the parties can actually prove, gather evidence related to the merits of the litigation. But the merits are not at issue right here.
Got you. Because they're arguing about the forum. Okay. I love it. All right, real quick here, Amethyst says this. If the state can prove she has already talked to a probable witness, wouldn't that be a precedent to request a gag order?
Man, this is. I have a friend who's a prosecutor in Tennessee. He might be watching this right now. I'm not sure, but I want him on to answer some of these gag order fundamental criminal trial questions. I think he'd give you some good answers. But yeah, when it comes to like probable witnesses being, requesting a gag order, again, I think, I'm not really sure on how to answer that, but I think when we say gag orders, the first thing we have to think about is the First Amendment and what type of restrictions are you putting on an individual, whether it's Candace Owens, a witness. I mean, that's going to, it's not always as nice as it sounds because a lot of people just don't want their free speech rights violated, but I really struggle to give you a good answer on the gag order question.
Oh no, that's fine. That's fine. Okay. I don't know. And I don't know if we talked that much about it. Are you familiar with the whole Mitch Snow?
No.
Okay. This was a rough one because this is allegedly Candace's trump card, her great eyewitness who can confirm the Egyptian planes were tracking Erika and TPUSA, and allegedly he saw again the security guard and Erika at this special secret military meeting 2 days before Charlie Kirk was killed. Long story short, it's really come out that the guy's full of hot air. And so what Ruben is saying is, can you describe the traits of a credible witness and compare them to Mitch Rambo Snow? It is such a crazy story to try to explain it. I actually think this is part of Candace's strategy. Her stories are so elaborate. There's such a Rube Goldberg type of scenario that it's hard to explain, to the point that you almost can't even explain it to somebody because they just sound crazy. You're going to look at me like, Jason, are you okay? Are you stroking out? Are you all right, Jason? Because that story is so crazy. But what would be a credible witness? We don't have to compare it to Mitch Snow, but what would be a credible witness in your mind to anything going on with Tyler Robinson and Charlie Kirk's murder?
Yeah. So fundamentally, if a witness is called for their own testimony, they have to understand their oath, which is they have to provide the truth, of what they're saying. They declare that what they're saying is truth under penalty of perjury, and they truly have to understand that oath. So if you're able to show evidence that they don't understand how to tell the truth, this is where you could get a witness for lying in the past. Imagine you have a witness who lied on a resume about some of their experience, or lied about what they did at this previous job, or what skills they have. That could be used as evidence against them to say, hey, look, this witness doesn't even understand, the ability to tell the truth. So that's why you really, should be honest in a lot of your dealings, even in your own personal life, because if you're not, it could later come up against you if you're called as a witness and be used as evidence that you don't even know how to say the truth or, acknowledge your own oath. And then two, with respect to understanding your own oath, you also have to have personal knowledge, generally, of like what occurred. So you have to have either seen it, heard it, smelt it, touched it, you name it. You have to have that personal knowledge. So if we're dealing with a witness who says, oh, well, I didn't actually see it, but X person told me, that's not a credible witness. That person is just regurgitating what they were told. And that, again, we're focused on witnesses who actually saw it, actually heard it. And so whoever this witness we're talking about is, the first thing I want to know, did they see or hear or whatever they say they heard or saw? And does this witness actually have the ability to tell the truth? If we can show that, hey, he'll spread things all the time that are lies, let's go ahead and pull that up and question maybe some of this credibility aspect. Show he doesn't understand his oath.
Okay. So digging in the crates is not uncommon for a witness that you want to, I guess, discredit, or you want to show that he or she, you want to press on an area to show that he or she is not able to do their oath. I like how you said that, to maintain the oath. Is that fair?
Yes, but the only issue is there's a bit of a line. In law, there's a doctrine called the collateral matter doctrine. And essentially in this type of doctrine is you don't want to make many trials out of witnesses. So you can't just put like a witness on trial every time and say, oh, well, we're going to actually focus this entire case on you and what you did in this, context. So there's a bit of a balancing act that's done, because, I think any witness you call, you could just turn it into a trial about them pretty much and try to distract from the main issue, which is trying to hold accountable the parties for whatever reason.
Okay. No, I totally get it. I was laughing because if you are familiar with the YSL trial here in Georgia, there was a witness that literally took over the trial for almost a month. And it was just, his name was Little Woody. If you just do a Google search, Little Woody YSL trial, it is the funniest thing. I mean, he was the most cooperative witness you'll ever see. And he would be on there for hours. I don't know. I don't remember. What you mean? I don't know. Literally, and they just kept, it was so bad, but he literally took over the whole, that was a whole mini series of the entire thing. It was literally a month of Little Woody, and it was the best. It was the best.
Yeah. And then too, just something else that kind of popped into mind. Imagine you have a witness that says a statement, back in 2024, 2025, right? And then, at trial, they say something different. You could then bring in that prior inconsistent statement and use it against them to impeach them and say, hey, which is it? You said on this date it was this, but now here today you say it's this. Like, why should I believe you? Do I believe you now, or do I believe you back then? So that's another way you can poke holes in the witness.
I'm telling you right now, if you want some fun, go back and look up Little Woody, because first of all, the YSL trial was multiple years in the making. So when he first gave his testimony, I want to say it was like 10, 12 years before, he was saying something completely different than what he was saying now. And so like they did try to impeach him with his own testimony. Hours of us watching interrogations and hours of it. It was the worst. But again, like he's like, look, yeah, I was scared back then. I thought I was going to get killed. I'm telling you the truth now. So I like that, because it's a good example of what you're talking about, impeaching a witness for sure. So thanks so much for that, Ruben.
Yeah, and the witness is going to have an opportunity to explain the inconsistency. So here you made that example witness, and like that was his explanation: is I felt threatened in the past, but today I don't feel threatened, and that's my reason for the inconsistent statements.
Yeah, so it was very interesting. But all right, let me see what we got here, my friend. Nick, this was fun, man. Thank you so much, man.
Yeah, this was great. I love talking law.
I can tell. And I appreciate the fact that not only are you new to this, but you are actually very willing to share what you know and say if you don't know something. Hey, I don't know about gag orders. I don't know about that. Sequestering witnesses. I'm not familiar with that, but I like when you do have it, you're willing to share, and that's the part that I think the audience really appreciates. I'm just trying to make sure I didn't miss anything else. Real quick question. If Candace Owens be called to take the stand in court in any of these or related cases, can her questionable judgment and her broadcast material in her podcast be used against her? Wow. Because that's a body of work that could. So let's say she's called as a witness in the Macron case. I don't know if they would, but let's just say they did. They call her as a witness. Can they bring up all of her stuff that she's said in her podcast on her? Or would they need to do that?
Yeah, no, for the podcast material, those would be the actual acts themselves that gave rise to the litigation. Her Building Bridget series and all the statements made therein, that's one part of the defamation claims. There's also allegations related to criminal conduct of the Macrons, right, and that's also being sued under. So all of that type of material is actually what factually gives rise to the complaint as we see it today. And so, yeah, when it comes to being used against her, it's used against her because those are what create the substantive allegations that are being recovered on. And then with respect to the questionable judgment, I think that's when it's just going to come down to having to like maybe impeach Candace Owens or show at the time she made certain statements that she didn't have personal knowledge. So, if she's at trial and she's being deposed as a witness in front of the jury, if it ever reaches that point, and then she says answer A, but then you're able to show up in the past that it was answer B. Well, I would ask her, I'd say, well, today here you said answer A, but in the past you said answer B. Which is it? And can you explain why your testimony is not consistent? And we'd have to see what she says. And really what we're trying to do is the jury's going to get to decide her credibility. They're going to see, is her explanation sufficient? In that example you gave me earlier, the jury was likely staring at that witness to see like, hey, is this explanation sufficient to kind of explain the inconsistency, or is this just really convenient now that suddenly they've got this better litigation position, but it's actually inconsistent with the past?
Wow. Okay. I'm not going to keep, because now I have another question.
No, please. If you got some more, I'm not going to go.
All right. So, and this kind of goes with, because there's out here in these social media streets, there's a lot of people who wonder, because Candace has had multiple babies back to back to back. She's had 4 babies in like 6 years. And so lots of, moms, dads are not saying this. Dads are being quiet. But a lot of moms and women are saying that there might be some hormonal issues with having that many kids back to back and not giving yourself time to recuperate and such of that nature. So I'm going to build off of that and say, can she claim some diminished responsibility? because of, mental duress or hormonal imbalance, or what is it called? Postpartum psychosis, anything like that. Could she use that? And when would they reveal that as a defense?
Yeah, so that's a bit of a novel legal theory. I've not heard of diminished responsibility as, a defense. Although I guess it could be, if there are certain individuals that have like mental incapacitations, like, maybe.
Here comes your friend. There we go.
Yeah. So yeah, when it comes to insanity, so if we were dealing with an actually mentally challenged individual and they were stating comments about an individual that were perceived as defamatory, I think there would potentially be an available defense, and we could plead that mental incapacitation,
wow. Okay.
To that. And we'd have to show facts related to that, right? We'd have to prove our defense and show that there's, we have a doctor, a psychologist that says my client is mentally challenged and doesn't really understand what he or she is stating at certain times, and unfortunately that does happen, with people with mental challenges. But I don't think Candace Owens is mentally challenged. She actually seems very smart enough and savvy to understand, for example, that her statements can get popularity, and that if she says certain things that she's can get views. And understanding that correlation and her ability to act and get benefits, I think reveals that she's not actually mentally incapacitated in any way. Now, when we're talking like diminished capacity, I think it's, you're either mentally incapacitated or you're not, trying to hover this like in between line of, I'm actually full capacity and I deserve all my legal rights. Oh, but by the way, I actually don't have to face all the accountability. I just get all the benefits of full capacity, but none of the consequences. There's not really a mechanism in law for that. So I've not heard of any diminished capacity in that argument. The only thing I could theorize is that Candace Owens would have to plead mental incapacity, but I don't think she's going to actually be able to show enough evidence of that, because she actually seems, she seems quite smart in her own way, or she understands her actions and the nature of them and the consequences they can have. She might not want to be held accountable for it, but that she understands, I think, what she's doing.
Right. Okay. No, I like that. Thank you so much, Amethyst. So, Nick, allegedly, I heard, based upon information, that you went down to the Starbucks today and robbed them, allegedly, and you pistol whipped the barista, allegedly, and you stole the tip jar, and you stole a bag of Holiday Blend coffee, allegedly. Can people really hide their slander and continuously saying allegedly and then continue to pass it as fact? Can I get it? You can't. At what point does the allegedly start to no longer work?
Well, first, I only stole the tip jar.
Come on, man.
Yeah. No,
my sources told me you took the Holiday Blend coffee too, man.
No, defamation per se. Now we're dealing with criminal conduct accusations. No, but when it comes to like allegedly, generally that's why whenever you read publications, right? Like if you go on like a news channel and they're saying, Tyler Robinson allegedly murdered Charlie Kirk,
right.
They do that because you are legally required to say that, because allegedly modifies the statement. So it's no longer a statement of fact. It's just, these are allegations. They're not conclusively true. And so you can hide behind that term allegedly. And so long as you state it sufficiently clearly and you're not implying fact, you can say it as much as you would like. And if there's basis for the allegations, right? Like, hey, Tyler Robinson's been alleged to have murdered Charlie Kirk. I'm not calling him guilty of the crime. I'm just saying these are the allegations. So I think, just the repeated aspect of it, you're allowed to repeat the term allegedly. So I would see it tough to try to, I would see it tough to cross into. I mean, sure, you could say it disingenuously and try to walk that line, but there's a reason you're saying allegedly, and you're kind of like not, you know what I mean? You're not really,
right.
I mean, you are kind of conceding it's not conclusively true, I guess.
Or, okay, because you said there's a fact. Like, for example, Nick is sitting in his studio with two paintings behind him. That's a fact. I mean, we can all see it. We can all affirm it. I could say allegedly Nick is wearing basketball shorts and some old rundown Jordans. You can't see that, but I'm making a statement but I know I'm making it up.
Yeah,
I'm making it up and I'm using allegedly so I can just besmirch you and say something crazy to make people laugh in the comment section because that's what I do.
yeah,
So my allegedly here really is not rooted in reality at all. Now I could say allegedly Nick is wearing a matching gray pair of slacks that matches his jacket. That would make sense to me, but the whole thing about basketball shorts and rundown Jordans, I'm just saying it, but I'm using allegedly as like a shield.
yeah, and I think you bring up a great point in this aspect. I think there must be, and I have to look up the law on this, but generally there's likely you have to have a reasonable basis for the allegation or stating it. And so where you're stating it, you say allegedly, and then you just insert whatever outrageous fact, thing you want. But that quote allegedly, where did you get that allegation? Who did you hear that from? If you just came up with it on the spot, exactly. That might actually cross over into, well, this isn't really an allegation. Like, oh, he's allegedly done that. Well, nobody's alleged he's done that. You could just say that and just, that's almost a false statement of fact in itself. Is like, you're almost implying that there are others.
Well, there's another one. See, the other Jason said it. The other Jason said it, and that's where I got it from.
Oh, yeah.
Well, see, I heard it. I heard it said that Nick is wearing some rundown basketball shorts and some old Jordans. There you go. And somebody told me that.
The multiple personality, you know what I mean? The other one.
Wait. That was editor Jason. So, because I hear people use it all the time, and actually, I've actually seen it after the fact has been concluded that a person has been found guilty, and they still use allegedly. I'm like, why are you using allegedly? He did do this, or she did do this. We're not. Is there a reason why that might happen?
That's a good point. I think once they're convicted, you can say it. There is no more allegedly this. So whoever wrote that just did a poor job, I think, in drafting that.
I got you. Let me see what.
Allegedly, I think that's funny.
Wait, allegedly, man, allegedly. Okay, there was a question. I'm sorry, there was another question for you right here. There we go. All right, can you ask about tax write-off aspect of her lawsuit? She is making all this money off of Kirk while writing the taxes off due to her lawsuit costs.
I don't really have a lot of information on how she's doing her taxes or the businesses are. So it's really difficult for me to comment on, what she's writing off or what she's not. I don't have any information on that. And then also I'm not really like a tax attorney on how to deduct taxes and things like that. I mean, if you had to litigate cases, I could potentially help you there. But when it comes to tax deductions, I'm not really sure of the propriety of that. And you'd probably want to see a more tax-focused attorney and ask that question.
For sure. I got you. Yeah, like don't go out and get sued and use that as your write-off strategy. Yeah, don't do that. That would probably be bad.
Yeah.
No alleged after. I don't remember where it was, Stealth. I agree with you. I just don't remember what it was. I want to say it was the YSL trial where they were using alleged still. But let me see. Does the taxes not the owner? Okay. Lots of good conversation. Thank you for this update. I was wondering what's happened to the Macron's Candace case. Well, thank you so much. At the current moment, it's still in process. Now, in your estimation, you said it probably wouldn't even get in under full speed until like 2027. So if just in your estimation, so with jury and all the discovery process and so forth, if it did go to trial, it would probably not even be to 2027.
Exactly. And then too, the parties, let's say they say there's additional discovery needed close to the trial date. Maybe one of the parties requests a continuance of the trial, and then suddenly the trial's pushed back another 2, 3, 6 months. And so I mean, a lot of it's going to be gathering discovery. And that's going to be the question is like, does Candace Owens want to put herself through all these discovery measures? Also, I think the Macrons got to ask that question too themselves, because they're going to be, subject to discovery as well for the next 1.5 years, 2 years. So would that incentivize them to settle for some type of way they could if they feel like they won that motion to dismiss stage.
Right. No, I got you. Yeah, so we got to get them quotey quote fingers, get the quotey fingers. Okay, here's a good question, and I think this one kind of wraps it up. What's the likelihood that Candace Owens is doing all of this, the Macrons, TPUSA, simply as a quest for fame and attention? I'm going to give my own answer. I'm going to go with about 80%. I'm about 80% certain that is exactly why she's doing this. But that's
some people might choose a higher percentage than that, because ultimately when you start looking at, the monetary figures that can come in, the viewership, there's such a strong incentive to say certain views or opinions that maybe even the content creators themselves don't believe, but they're just driven by that incentive to do so. And so, that could be a possibility here. And, we could, if we were in Discovery, we could ask Candace Owens that too. Like, hey, is this a quest for fame and attention? Now, her lawyers might object to that framing of the question,
for sure,
as in some sense. But I think you could get to that point and try to reason that out. And then for other content creators, I would just put it to you like this: if you were a content creator out there and you could only get like 100 views for your videos, right? But then all of a sudden I said, hey, if you talk about this subject and I could guarantee you could get 50,000 views per video, I could tell that content creator to talk about anything in the world. They're probably going to talk about the video, giving them 50,000 over 100, because that's probably some of their goals, whether it's money or attention.
Yeah, great point. I like how you did that, man. I feel like you were talking about me, though. I feel a little slighted. I might not invite you back again.
I wouldn't talk about you. I'll put it to you like this: I do certain views on my my YouTube about like, shoot, I could do something about a football, thing. And like, people just don't really have an interest in it, and I'm not necessarily like a former NFL player or a former NFL coach or anything. So people probably ask, hey, what is this guy giving me that I can't just watch on like NFL Network or ESPN, you name it. And so like, I don't really blame them in that context. So it's like, you got to do, what you think can sell and, what you can make that can work.
Yeah, absolutely. Hold on. Somebody made a statement and I don't think they know everything about. All right. Somebody, I guess this person is very interested in this. Thank you so much. You do have to get 1,000 subscribers. They're not just viewers, but subscribers. But a lot of people don't know, Nick, that you also have to get the 4,000 watch hours. And that 4,000 watch hours is a Herculean task for some people. Just to you can get all your cousins and frat brothers and knitting circle to subscribe to your channel. But if they're not watching it and not adding up that 4,000 watch hours, you are looking at a pretty steep hill to climb. So anyway, I just want to point that out to the person. Just explain watch hours.
And two, like going back to the incentive, it's like, even for me as like a creator, like I have to consider, how do I want to spend my day? Like I can either work my actual lawyer job, right, and go bill hours and write motions, and I get paid for that. This is money I'm in my pocket. But if I'm doing these YouTube videos on subjects that people really don't care to view, it's more of just a personal project and like an artistic expression, I think, more than it is like what I'm trying to get towards a professional goal in some sense. And so, like, again, that's kind of why I do my channel is like, sure, I know it kind of can bring some attention to my channel, and that's definitely a benefit because, when you're, starting business owner and stuff like that, you got to, find a way to get business. And so like, if I can spread legal knowledge on a popular subject, well, that not only kind of helps me with the attention, but, maybe it brings me business in the future. So that's a huge incentive for me is like, hey, what can I do to show people that I have some knowledge on this subject, I can speak about it. And if they were wanting to hire me, I've given them enough material to do so. And so that's a huge incentive of mine as well.
No, I agree. And I think you've proven it to us. I think you've proven it to us that you know what you're talking about. I saw a question right here. What is Candace's profession, by the way? She's a podcaster.
Yeah. I think housewife / podcaster, because when your husband has 250 million, you don't really have to work or however much he has. So
you're right.
I think she really can kind of do whatever she wants in life. If she wants to sit home and make podcasts that draw attention to herself, She can do that. That's her right. Obviously, she's got to be within the confines of the First Amendment and not defame others. And so we got to remember that. But
right.
if I had 250 million sitting in the bank, I might be making YouTubes or hiring other people to make YouTubes for me. We'd have to see.
Right. I love it.
If I had 250 million, I might not have a job. You never know.
I love it. No, I think, well, we're glad that you've decided. What matter of fact, what pricked your fancy to actually start putting content out on YouTube, by the way? Because I think I just ran across a video you did. I'm always interested in lawyers speaking about the Macron case because, again, I'm a pre-K law student. I know nothing. So when I see lawyers do it, I'm like, hey, this guy is quick, is very legal to the point. So what possessed you to do that? I don't want to say possessed you. What pricked you to do that?
Yeah, possessed me, getting taken over. No, really, the reason I started doing it is, I just working as an attorney. I was always an associate. So as an associate, you're an employee and you're subject to the control of your employer. And so one of the issues I always had is, like, as an associate attorney, I wanted to do stuff like this and, give my opinion on things. It's just the issue is your employer doesn't always want you to. Your employer generally doesn't feel like you have the professional judgment to state your views. And so a lot of employers I worked for didn't actually believe in me, in my professional judgment. They thought, I would slip up and say something. Maybe it was prejudice on their part because, I have a Southern accent. I'm dealing with New York attorneys or California attorneys, you name it. And so you never know. But, ultimately, I stopped working for a firm. It didn't end, in the greatest of circumstance there. And I just asked myself, do I want to be an associate attorney where I'm subject to the control of an employer? Or do I want to go do this on my own and, go start my own business? And I'd worked for a bunch of solo practitioners, some in Jersey, some in one in LA, actually, for a year and a half or 2.5 years from Persia. And they were just young. They were entrepreneurial. They were go-getters. And it gave me a model on how I could run my own practice. So I'd had about, 2.5 years of experience up to this point. And so I just said, yeah, I can do this. And I spoke with a bunch of attorneys I know in these professional networks, kind of sat down with about 10 to 15 local, well-accomplished attorneys here in San Diego to ask them their advice on how I should move about my affairs to, A, pay the bills, B, bring a long-term future to myself. And they had great advice, and I've been following it. And so, I love it. I started working actually with a firm in Irvine, California on like a contract basis. So basically the way that works is, hey, they give me, an hourly thing. If I do work for them, they'll pay me hourly for it. You do your, paying your bills that way. But then, outside of doing your contract work, and I do contract work with about 2-3 other attorneys too. You do things independently. You get creative, and how can I get people to discover who I am? And I've got a website. I got a recent client actually through my website. So that was nice. And, a lot of it's just trying to be entrepreneurial, get some views, get some people to find out who I am, my product, my brand. And, that's a challenge, trying to get your brand out there.
I like it. Here, let me, make sure matter of fact, let me can I put your website in the chat? Is that okay?
Yeah, please.
Okay.
But huge business incentive because I feel like a lot of people in the world, especially maybe from where we're from, in the South, like you don't really ever want to bring a lot of attention to yourself, someone as an individual. So there's like an apprehensiveness that can come with like starting to post yourself, whether it's on social media, YouTube, you name it. And so like once you kind of overcome that fear, find something you can talk about, have some confidence and like maybe get business for yourself, like it's a great way to kind of live your life and expand some of the, boundaries that you've had.
I love it, man. I love it. Okay. Let me also make sure I drop your link to your YouTube channel. Make sure, just in case people have not already checked you out. There you go. It's right there. Nick, please clarify the difference between attorneys versus lawyers versus trial lawyers. Isn't there a distinction like British law, barrister, and solicitor?
Yeah, no, this is an interesting question. So
okay, I thought the same things. Okay.
Yeah. All right. Actually, so I actually speak Spanish and Portuguese. So we also have some different terms when it comes to that. So like English, when we're dealing with a lawyer, we either say lawyer or we say attorney. It's the exact same thing. Now, if we say trial lawyer, you're just indicating that this lawyer does particularly trials. You could say appellate lawyer, and then you're indicating that a lawyer does typically appeals. Pretrial lawyer, that lawyer does pretrial. You could say pretrial attorney, trial attorney, appellate attorney. Doesn't matter. When we're dealing with barristers versus solicitors, I'm not exactly sure. Well, solicitor, I know there's a couple in the United States where you'll have like the Solicitor General who, you know, the United States, they're typically responsible for some of the legal affairs, as I understand, that go on in the federal government. So that can maybe indicate a prosecutorial role. The solicitor is kind of, I'm not so sure with. But barrister is just another name for attorney or lawyer in Britain, as I understand. It's not really anything too special other than they have their own name. In Spanish, we got abogado. And then in Portuguese, we have advogado, which actually translates to advocate. So if you're in Portuguese and you're conceptualizing of a lawyer, you're actually thinking more of an advocate. And that's what you're actually stating. So a lot of our jobs as lawyers or attorneys, barristers, you're an advocate for your client. So it's just a simple way to think of it.
I like it. So do you speak Spanish with a Southern accent as well?
No.
Like South Portuguese accent?
No, not at all. Actually, like I actually run a Portuguese group here in San Diego. So we meet up usually about once or twice a month, and we kind of, we'll practice our languages together. And for me, it's great because my livelihood depends on communicating myself and writing.
For sure.
And when you're able to speak another language, especially Spanish or Portuguese, there's so many like vocabulary similarities or grammatical ways of expressing things that make you sound more intelligent, make you sound like a better communicator. And quite frankly, it's just having a more expanded vocabulary and way to express yourself. So I think it's really good.
I love it. Okay. Somebody asked, how old are you, Nick? If you want to say, he's many moons, whatever.
It's funny. I get this question all the time. And usually when people find out I'm an attorney, they up the number. If you had to guess, what are you guessing?
Okay, in the chat, how old is Nick? Here, I'm gonna leave that question up there. In the chat.
And if in the chat, if you're factoring in that I'm a lawyer, just disclose that so we know. What are we getting?
Okay, I see 28, 33. I said 33. 25, 26, 35. It's a simple question. Just answer it. Mid-30s.
I'm actually 29.
For real?
Yeah.
Oh, dang. I just knew you were going to say 35. Wow. Okay.
Truthfully, let me tell you this. That's another challenge when you're like a young business person, is you're going to run into people that, quite frankly, age is very important to them, and they might not state it explicitly, but the amount of situations I've been in where, people kind of underestimate me based on my age, it's kind of comical because, quite frankly, a lot of attorneys I know, a lot of their livelihoods dependent on being knowledgeable and gaining knowledge over years. But it's like now we have such knowledge available through technology. It's like, I feel like sometimes I know as much as an attorney that's worked for 40 years in the profession, simply because the information is so easy to access relative to when that attorney was my age doing that work. So yeah, I don't really feel too insecure about it. My biggest insecurity for my age probably comes from the fact that I'm aware of the people I'm dealing with might not take me as seriously.
Okay. No. Well, I have to admit, you had me stumped because I would have easily said 35. I said 33 because I wanted to shoot low, and I was way off. So, okay, cool. And yes, it is about knowledge and integrity. I appreciate it, man. All right, good, man. Good. Oh, we got another question. Not all lawyers can try cases, true or false?
Oh, very true. I think, because trying a case generally indicates, doing a trial. And to be a trial attorney, I actually think it somewhat takes like performance acting skills. I think a good trial attorney knows how to put on a performance and like engage with the jury in front of him. And I think acting classes and theater classes can really help that. But if you're more of an analytical thinker, sometimes performing is a bit of a difficult task because maybe you're overanalyzing certain things. So maybe more pre-trial is better for an attorney like that. And then, appellate law is the same thing. Like if you love research and writing, and appellate law is where your bread and butter is at and that. So I think, there's different skills available to different types of lawyers, and good lawyers are definitely versatile, but some lawyers are also very focused as well in a certain area.
Yeah. I'm learning that, there's contract lawyers, there's social media lawyer and all that kind of stuff like that. I wouldn't want them necessarily to be my trial lawyer since I'm suing Nick because he stole the tip jar from the local Starbucks or whatever.
Exactly.
Right. Or defend Nick rather, since he stole the tip jar. Absolutely. All right. There's some good commentary back here. I appreciate everybody. I'm just looking through to make sure I didn't miss anything. Excellent. Excellent. Well, Nick, thank you again, man. This is a lot of fun. You are welcome whenever. If something pops up, I'll send up the bat signal. Once we find out that the judge has thrown out the dismissal and the case is going to discovery. Hey, this is a question I had. This is my last question. What's the likelihood that the Macron case will be televised? Do you have any?
Oh, yeah, that's a good question. I think obviously a media company of some sort would have to make a motion for that. It could likely be granted because, there's a huge public interest in a case like this. Obviously, Tyler Robinson would have to challenge that motion and, oppose it and give the grounds and why he believes it would be unfair or things of that nature to broadcast it. But I don't see why it wouldn't be broadcast. It's going to ultimately be up to the judge and the judge's discretion. They have a lot of control over their courtrooms. And, we'll just have to see how the motion and the opposition kind of work out. But I would say maybe probably greater than a 50% chance.
Yeah, I can't see a reason why not. But oh my gosh, I think that would be bananas. But yeah, okay. Well, again, thank you so much, my friend. I appreciate it. It's been a lot of fun, and I appreciate your insight. If you do, of course, run across anything else and you want to talk about it, I know this guy who'll gladly have you come on and we can talk about it. And if your friend in Tennessee wants to talk about trials and such of that nature and sequestering jurors, tell them come over here. I got some questions. And,
all right.
We'll definitely talk it up. But sir, thank you again. You do have some videos coming up today or this weekend, am I right?
Yeah, actually, so we've had one video posted today at 9. We're going to have some more, posted over the next couple of days just on different discovery tools, which would be available in the Macron v. Owens case. In addition, we'll discuss some of the discovery tools that would be available in the Erika Kirk v. Owens case. I notice a lot of viewers really want to dive into understanding the different types of evidence which could be gathered. So I've just tried to put together some videos explaining that. And then maybe, if certain parties don't cooperate, what the remedies would be, such as motions to compel, sanctions. And we'll just try to dive in and analyze different legal topics with respect to the case.
Okay. Well, I dropped your link in the chat. Let me just double check and drop it again. Please make sure y'all go check out what Nick is doing. And of course, make sure you subscribe to his channel. Give him those watch hours, all that kind of good jazz. Drop some green hearts. Let him know that you appreciate what he's doing. Everyone, thank you so much for the best live chat on the internet. If y'all could just on our way out the door, make sure you tip your waiter. Can y'all please just put Nick in the chat? All right. Put Nick in the chat and we will definitely see you. I'm going to be back this evening. We're going to be talking about Nicki Minaj and I'll have Keisha King on. We'll be talking about that this evening. So everybody, thank you again. I appreciate each of y'all. And Nick, I'm going to drop you back there for a second and I'll be right back. Everybody, thank y'all so much for being excellent guests. I appreciate y'all. Thank you so much for supporting Nick. Please make sure you go check out what he's doing over there. He does a great job. If you like what he said here today, I guarantee you'll like what he's doing on his channel. So definitely go support him like that. Everybody, thank you so much. Tip your waiters on the way out the door. Make sure you drop those green hearts out on the way out. And until next time, everybody, actually, I'll see y'all at 6 o'clock Eastern Standard Time. Grace and peace. Take care. Thank you so much for tuning in to another episode of the JWhit Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.